Forum.
Right. One big one. My email, Julie's husband sent a message saying that Julie's sick. But she'll try. We have to, if she has to make it, but otherwise she's not.
My email.
Julie's husband sent. Yeah, that one doesn't sound like
I was gonna say.
Small laptop. Good morning.
Morning.
Hey Ed.
Hi, how you doing?
Oh, fine. How are you?
I'm just fine. Are you going to want me to do the opening?
If you don't mind, that would be great.
I don't mind. I don't mind.
Lovely. Julie is sick today, so it's just the four of you
Okay.
until you have to take off. So we'll hear the first, what looks like the first 8 cases, but is in fact the first 5. The 3 cases against the town of Scarborough
Yeah.
are exactly the same facts, exactly the same submissions in the file, everything the same except the names of the complainants and a couple of facts about when they moved into motel.
Right.
Hear those, if it's okay with you, as one case, 10 minutes per side, same as we usually do.
Absolutely. Yeah.
Put on them separately at the end.
Their request that they get 2 minutes.
There was, I denied it on your behalf.
Already had some-
I figured you wouldn't be mad at me about that. And then the Earl versus Hassett and Maloney case. I have several requests from respondents to withdraw the case and take it off the agenda. I have no request from complainant. I have heard nothing from her. I did just receive the signed settlement agreement, which is great. And if this were not a case that was dual filed with HUD, I would actually be recommending that we accept the withdrawals. But because it's a private agreement, which we can't have in housing cases, I would have to treat it as a withdrawal without benefits, which screws up our numbers with HUD. So I will ask you to hear it. I don't know if the parties will present, so it may be very fast. It's a little logistical thing. And yeah, Kirsten Kelly's letter that you all have, she's requesting, in fact, not for you to reconsider it today. What she's requesting is for you to see her in person so she can request a reconsideration in person. Do with that what you will. The right to sue letter has now been issued for almost 6 months. And I would recommend that you not grant her that.
What is she going to be asking for?
She wants to meet with you in person, I think probably at the next meeting, to request reconsideration and explain why she's requesting reconsideration.
Okay. And what case is that?
It's actually not on the agenda. I sent you all
okay.
a letter. She just sent a letter asking. She got a right to sue letter in her case. All right, but I think we better get started. On these people. Last decade.
Well set.
All set.
Good morning. My name is Ed David. On behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device, cell phone, pager, etc., to ensure that they are silenced now. We have additional agendas, including the consent agenda, available in the back of the room and online. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted time. The commission has voted on those cases and will not be considered further today. We haven't voted on them yet, but we will. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written statements will be accepted today. Cases will be called in the order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium to provide the most relevant arguments in the case. The time is limited to 10 minutes. The time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. The procedural rules of the commission specify that your arguments may address only one, relevant factual errors, two, relevant omissions from the reported facts submitted during the investigation, or three, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposing party. Please be advised that commissioners may ask questions. I will ask that you introduce yourself as you come to the podium. Thank you. And our director has some further instructions about presentation, I believe. Kit?
Yes, thank you, Ed. So we have a couple of things to address before you will vote on the agenda. One is a request from Kirsten Kelly to meet with you at the next meeting to request reinstatement or reopening of her case E22-0270 ABCD. It's Kelly versus the Humane System and some other associated people. She had requested a right to sue letter in November. It was issued in November. The case has been closed with the commission since then. We have spoken, she's spoken to the investigator assigned to her case. She and I have spoken at length. I have explained to her that at this point, the case is closed with the commission and that really the only thing left for her to do would be to request reconsideration from you all, which you may grant, or you may grant her the opportunity to present. That's up to you, but I would need a motion to for some resolution. And then I don't think she's on the call today, but I will forward that on to her.
Just a quick question. Has counsel for the university taken a position on the request?
They're not aware of the request at this point because the case is closed. Okay.
Is there any established procedure to request reconsideration? Is that in our rules?
There's a way, there is a procedure for requesting reconsideration of your decision. This is unique in that you would be reconsidering something you never considered in the first place. She requested the right to sue, and therefore we gave it to her as we're required to do by statute. So there is no procedure for this. I mean, I assume we would treat it as any other case. So if you would like to make a motion to reconsider, which isn't even what she wants to come before you. So it would be a motion to hear Ms. Kelly, I believe, on her request for reconsideration. You could do that. I think that would be proper procedure. If you do not want to do that, then just no one make a motion and we're done here, I think.
Okay, great.
You think that the thing that we need to decide right now is whether or not to hear her in person?
That's what she's asked.
Okay.
So yes.
Well, I move that we deny that request. I just don't see any real basis for it.
Second. Mark seconds.
All right, it's been moved and seconded. Any discussion?
Well, just curious, is there any particular harm by granting the request, or is it simply the acknowledgement that we're setting the precedent?
It's the precedent that I'm concerned about. This case has been closed for 6 months at her request.
Any further discussion? Right, seeing none, in accordance with our remote participation policy, I will ask that you indicate your vote both visually and verbally. So Commissioner David.
Yes, for the motion to deny, that's the positive, correct?
Yes.
Yes.
Yep. Yes. Yes. If you vote yes, you are in agreement with the motion to deny her request to meet with you.
Yes.
Okay. Commissioner Douglas.
Yes.
Commissioner Walker.
Yes.
Commissioner Sanders.
Yes.
All right. And the second thing to consider before you vote on the agenda is Earl versus Hassett and Maloney. This is the case on the hearing agenda today. I don't have H23-0404 A and B. It is my understanding that the parties have reached an agreement. I have not heard from the complainant, who is the only party with the authority to withdraw the case or request withdrawal of the case at this point. So this isn't so much a request for withdrawal as it is, I think, a request that I ask you to dismiss the case. I'm not entirely sure. In any case, I would ask that you keep it on the hearing agenda and that we hear it later this afternoon. I'm always glad when parties can reach an agreement, but in this case, it all happened a little too close to the deadline for me to really parse what's going on and who wants what. So I would ask that you keep it on the agenda. So I would need a motion, I think, to that effect.
So moved.
Second.
It's been moved and seconded. Any discussion? Seeing none, if you vote yes, you are in favor of keeping the case on the hearing agenda for this afternoon. Commissioner David,
Yes.
Commissioner Douglas,
Yes.
Commissioner Walker,
Yes.
Commissioner Sanders.
Yes.
Okay. And now you can vote on the adoption of the agenda and consent agenda.
I'll move adoption of the published agenda and consent agenda.
Second.
It's been moved and seconded. Any discussion? Seeing none, if you vote yes, you're in agreement. Commissioner David,
Yes.
Commissioner Douglas.
Yes.
Commissioner Walker,
Yes.
Commissioner Sanders.
Yes.
I keep wanting to ask Commissioner O'Brien. Here's a fun question. Do you all have the minutes for the March meeting?
No.
Okay, well then I won't ask you to vote on them. They're pretty short. I will send them to you and maybe we can look at them during the lunch break.
Okay, I was afraid that I'd overlook something.
Nope, just a little glitch in the system. So we'll skip that. Would you like my director's reports?
Yes.
So for personnel, Chelsea has been promoted to business manager, which is very exciting. She'll continue doing the meetings and is moving into doing more of the accounting with Michael, which is great. And we have posted her old secretary associate legal position. So hopefully we will have somebody in that spot in the next month or so. And we are also currently scheduling interviews for the vacant investigative position. So we should be making offers sometime in the next couple of weeks, which is great, getting closer to being fully staffed. You have a memo from Jane, I guess probably purporting to be from me, but really from Jane, about conciliation. We have 3 cases in conciliation. We've had 5 unsuccessful conciliations since the last meeting, 1 successful conciliation. And we do have an agreement that I will need you to approve in H23-0321A and B, O'Neill versus Executive Properties and all. Why don't we do that now, if that's okay? Do I have a motion to approve that agreement?
So move.
Second.
And moved and seconded. Any discussion? Okay. Seeing none, if you vote yes, you are in agreement. Commissioner David,
Yes.
Commissioner Douglas.
Yes.
Commissioner Walker,
Yes.
Commissioner Sanders.
Yes.
All right. Anybody mind if I sign on your behalf? Fantastic. All right. The case summary report, we have had 55 new complaints since the last meeting, 17 dismissals, 9 administrative dismissals, and 4 right to sue requests, plus the 4 settlements, 1 private settlement, and 3 successful mediations for a total of about $136,000 to complainants.
Kit, remind me what the difference is between just dismissal and administrative dismissal?
We say dismissal for any case that we have closed before it gets to investigation. So administrative dismissals are for things like failure to substantiate or failure to state a claim or failure to participate in the process. Right to sue letters we've discussed
Okay.
are statutorily required to issue those if the case has been with us for 180 days. And we distinguish between mediations and private settlements. When I say mediation, I'm talking about cases that have gone through our mediation program. So we had 4 cases that settled since the last meeting, 1 in private settlement and 3 in our mediation program. Any other questions about those? Litigation, I would ask that we take an executive session, and I have no new business for you, right? And can we be
Yes.
in recess until 8:45?
Yeah, that's only 3 minutes, but sure.
Yeah. Take a stretch break, everybody. It's gonna be a long day.
Okay, I think we're ready to begin. So the first case is Velveteen versus City of Eastport, PA 22-0080. It's a recommendation that there are reasonable grounds. Is two of the recommendations, and therefore we'll hear from the respondent, City of Eastport.
Before we get started, I just remind everybody that please don't use the names of third parties or entities that are not parties to the case, according to our confidentiality rules. Attorney Mahar, you have 10 minutes. Would you like to reserve any of your time?
Yes, I'd like to reserve probably 3 of those for any rebuttal.
Okay, whenever you're ready, go ahead.
Thank you. The City of Eastport disagrees with the finding of the investigators that the city in any way discriminated against anybody for reasonable accommodations to hearing. The city is continuing to try to ameliorate any problems of public members being able to hear. During the pandemic, the city made its council meetings available to the public by Zoom, as well as in person when we were able to go back to in person. The city continues to try to accommodate everybody, including people with hearing needs, to the extent that they have even changed locations for their public meetings and have attempted to have public address type of accommodations at those meetings, and has tried to also have transcripts of them kind of live recording, and they've been using Zoom for that, and are exploring other methods for doing that, even continuously now. This is a city of 1,300 people. The council and the staff of the city, which is, essentially 3 people, is attempting to accommodate all of those 1,300 people. And they're doing the best that they can. They're evolving things over the course of time. Perhaps it is not fast enough to satisfy the petitioner, and maybe others, but it is certainly doing what it can with the limited resources and personnel that it has to do it. The investigator also indicated that the city of Eastport may have discriminated against the petitioner on the basis of not allowing the petitioner to be sworn into a city committee using her preferred name. When the petitioner made this issue with the city clerk contacted legal counsel, me, and asked how people should be sworn in. And I said, well, it's a legal proceeding and a legal oath. People should be sworn in using their legal name. And that's what she did with the petitioner. The petitioner then got records from the city that indicated that a few people had been sworn in with nicknames, but didn't appear to be any who were completely fictitious names. Again, this is a city of 1,300 and odd people, and the city clerk is a lifelong resident, so she knows everybody, and she may have not been as formal with people who she knew prior to doing that. So there was absolutely no ill intent whatsoever or discrimination in insisting that the petitioner be sworn in using her legal name, or their legal name, I'm sorry. It is something that the city going forward from that point is requiring people to be sworn in using their legal names. And the whole, among the city's frustration over this issue is that if somebody wishes to change a name, it is a very simple, fairly quick as court processes go, and inexpensive thing to do, to go to the probate court and ask for a name change. There was simply no discriminatory intent. It was to effectively comply with legal standards of swearing people in using their legal names. I that's what I have to argue on the on that issue. It's something that should have been being done right along and was for the most part, but there are a couple where a couple of names that were nicknames, which is what the city clerk knew the person as, and it simply slipped through in that fashion. The city of Eastport does not make any attempts whatsoever to discriminate against anybody. The city has employees who are who are of minorities, who are of protected classes for the purposes of the Maine Human Rights Act. It's not something that is in any way intentional on the part of the city. Do any of the commissioners have any questions?
Well, are you all set?
Yes.
Okay, you'll have about 7 minutes and 15 seconds when you come back. So yes, any commissioner questions for Attorney Mahar? And I apologize if I just said 7 minutes. You will have 3 minutes and 15 seconds when you come back. I will continue to drink my first cup. Next, Velveteen, you have 10 minutes. Do you want to reserve any of your time?
Yes, please. I'd like to reserve approximately half of it, 5 minutes. I prepared a statement, if that's okay. I will try to keep it brief.
Okay, go ahead whenever you're ready.
Thank you. I'll focus mostly on my disagreement, my respectful disagreement, that there was not the investigators finding that there was not a hostile environment created by the city. I'd like to talk about a series of signs that have been popping up all over my neighborhood and all over the city for about 2 years now. Actually, well, since 2022, so about 2 years. The investigators' report states, quote, furthermore, while a complainant provided evidence to support their belief that counselor made and posted signs around the city with their dead name, there was no way to confirm this belief during the preliminary investigation. Respectfully, I do believe that there were ways to confirm the origin of these harassing signs that have been appearing around town. Those methods would have been proper police investigation, compliance with the Maine Archives retention policy, record retention policy, excuse me, and appropriate disclosure of public documents subject to FOA. I believe the Eastport Police Department systematically denied me access to proper investigative procedures, first through Chief Emery's failure. I'm sorry, am I allowed to talk about people that I've already submitted information on?
Not if they're not named parties.
Okay, I think
You can
they are
name the city of Eastport, but you may
Okay.
not name any employees or any counselors.
I understand. I will edit that out of my statement. I'm sorry. I believe that the Eastport Police Department systematically denied me access to proper investigative procedures through the chief's failure to appropriately identify the signs as a crime, and then in his refusal to investigate. I also believe that FOA entitled me to disclosure of a surveillance tape which captured the perpetrator hanging a sign at City Hall, and that the city of Eastport acted unlawfully when they withheld that and then destroyed the video without reviewing it. This action prevented me from independently seeking a court protection order. When city surveillance cameras caught the perpetrator hanging a sign at City Hall on November 7th, 2002, it was, I believe, the 5th of 7 signs. And I submitted an in-person FOA request for that footage within hours of its appearance to the chief. The chief declined to produce the tape, claiming that I had no right to it, even though it was of a public street, of a public place. According to the former city manager, the tape was destroyed 3 days later without review. At that time, the chief also notified me that he would not investigate the origin of the signs because he did not believe a crime had been committed. I argue that these signs, which outed my dead name, threatened me with homelessness, mocked my gender and my disabilities, one even targeted the children in my family, are consistent with the definition of stalking and harassment under Title 17A, subsection 506 and 210 of the Maine Criminal Code, which states stalking, a person is guilty of stalking if the actor intentionally or knowingly engages in a course of conduct directed at or concerning a specific person that would cause a reasonable person to suffer serious inconvenience or emotional distress, to fear bodily injury, to fear bodily injury to a close or to fear bodily injury to a close relation. The actor violates paragraph A, and the course of conduct is directed at or concerning two or more specific persons that are members of an identifiable group. Harassment says the definition of harassment is 3 or more acts of intimidation, confrontation, physical force or threat of physical force directed against any person, family, or business that are made with the intention of causing fear, intimidation, damage to personal property, and that do in fact cause fear or intimidation or damage to personal property. This ongoing harassment does meet the criteria of Maine Criminal Code. It's been a great trauma. It affects me by the effects include recurring nightmares, insomnia, PTSD flashbacks, panic attacks, intrusive thoughts, obsessive compulsive behaviors, suicidal ideation, self-harm, a really regrettable relapse in sobriety, and a 2-fold increase in my dosage of anti-anxiety medication. The signs have caused me.
That was your, I'm sorry to interrupt. That was your 5 minutes. Do you want to keep going?
I would.
Okay. All right,
Please, thank you. The signs have caused me fear, serious inconvenience, and emotional distress, resulting in damages in the form of costs associated with increased security measures to my home and the need to seek psychiatric care beyond my insurance network. These injuries and their explicit association with the signs have been thoroughly documented by psychiatric medical professional Lisa Jacobs, PMHN, and previously submitted to the HRC. I'm sorry, the MHRC. In the evidence packet that I previously submitted to MHRC, I demonstrated the illegality of withholding and destroying the surveillance tape by consulting with Maine FOA Ombudsman Brenda Keelty and the Maine archivist Catherine McBreen. Archivist McBreen directed me to the record retention policy set forth by the Maine legislature, which states that once a disturbance has been reported to police, the police department has a duty to preserve that video until an investigation can determine there is no threat. According to Archivist McBreen, allowing evidence to be destroyed in this way.
I understand the archivist is probably a public figure, but please don't use her name.
I understand. I will scratch that reference now from my statement. I believe that if equitable due process were available to me from the police department, and if the city of Eastport had not destroyed the surveillance tape of the perpetrator, there would be overwhelming and undeniable evidence that the person responsible for this harassment is a former counselor who was removed from office for defrauding an official city document. The Eastport Police Department was in possession of multiple pieces of evidence, including several shipping boxes from which these harassing signs were constructed, all of them bearing identifying information such as address labels and client IDs. The construction material, handwriting, and unique symbology on these signs match existing signs and symbols posted to this counselor's personal property. In a previous audio and video submission to MHRC, I documented this counselor's long history of harassing me both in and out of city meetings. Examples include persistent misgendering and use of my dead name, even instructing other counselors to do so during city meetings. He openly mocked my disabilities. He filmed me from his seat on the council bench. He accosted me in the street with vulgar misogynistic language, which I produced a tape also submitted to the MHRC of that event. He sent legal threats to my private email and even attempted to corrupt a municipal petition I was circulating by signing a fake name to it. After I objected to a motion he once made to replace a vandalized pride mural with swastikas, this counselor published an editorial disparaging me and my partner and encouraging his, quote, base of support to ensure that, quote, troubled birds fly elsewhere. In perhaps the most alarming example of this hostility towards me, during his removal hearing, this counselor flew into a rage. In a video I submitted to the MHRC, the counselor leapt from his seat, lifted a chair above his head, screaming epithets, while unplugging all of the city's audio equipment. He then pointed to me and threatened, "You'll see, I'm just a resident now, you'll see." I believe that the Eastport Police Department denied me access to proper investigative procedure and that they wrongly destroyed evidence which they were obligated by state law to maintain. I believe that they mishandled evidence by failing to comply with FOA and the Archives Retention Act, all of which prevented me from independently seeking a protection order from the courts. And I also believe that the overtly anti-transgender content of these signs cannot be divorced from the city of Eastport's handling of this case. Another example of the hostile municipal environment is the accusatory way some city hall staff interact with me. Following the negotiations conference portion of the investigation, I reported that the city's deputy city clerk, not city clerk, deputy city clerk, had been making humiliating and intimidating comments towards me when I visited City Hall. The example I referenced during the conference occurred when I attempted to register my car. Noticing the discrepancy between the name others greeted me by and the one on my ID, he publicly interrogated me about the purpose of my alias, quote, alias. He asked if I was using a fake name because I was a criminal. He also stated that he'd, quote, already heard all about me and characterized me as a troublemaker. I don't believe that a cisgender person's name would have been subject to this level of suspicion and scrutiny. The report also states that it's important to note that the city acted promptly and appropriately when the complainant brought their concerns of harassment to its attention. City reprimanded counselor for his actions and ultimately removed him from the council. I do disagree that the city acted promptly and
Okay.
appropriately to my, yes,
That is your 10 minutes.
okay. Thank
Thanks
you.
very much. Any questions for the complainant? Commissioner Douglas.
Yes, good morning.
Good morning.
Yeah, I was curious about the surveillance tape of allegedly somebody putting up signs, right? And maybe I missed it in your submission here. How do you know what the tape shows? Have you seen the tape?
The tape, the sign appeared on City Hall, like at a utility pole that's right in front of City Hall, and there's a surveillance tape not 4.5, 5 feet away pointed directly at it. So if the tape existed at all, or if it was filming, which it should have been, it would have captured what was in that sight line.
Okay, so you're not saying you know who put up the sign, you're saying the tape would show who put up the sign.
It
Right.
would have, I believe, yes. Yeah, I also believe that if the, PD had followed up on the identifying information on the materials that the signs were made with, I think if they'd have followed up on the client ID, or the address, that was printed on them, I think they would have had a suspect. But because they refused to follow up because they didn't believe it was crime, no suspect emerged. I wasn't able to access. Yes.
I believe you've answered Commissioner Douglas's question, so I'll ask you to
Great.
just address the questions.
I feel very satisfied with your answer.
Thank you.
Any other commissioner questions for the complainant? All right, seeing none, we'll return to Attorney Mahar. You have 3 minutes and 15 seconds.
Thank you. With respect to this videotape, there is a video monitoring camera I'm not sure that anybody at the time knew how it worked or how it recorded and how it ran in a loop. The petitioner did in fact file a FOA request. The FOA information goes to the city manager. By the time the city manager attempted to locate the video in question, it was not there. It apparently runs in a loop, and it runs 24 hours and goes away. By the way, that was also subject to two different FOA requests that went to the Superior Court, in which the petitioner was part of the petitions that went to the Superior Court, and those matters did not.
Hang on just a second, Attorney Mahar, Investigator Brindley is that in the record?
The security court's not in the record, no.
The Superior Court decisions came in November after the record was closed.
Okay, we still can't discuss them at this hearing.
Okay. And record retention is not subject to archive rules for the city. Those state archives rules apply to state records, not to municipal records. And the simple fact remains is that while the city recognizes that these signs that were placed around are certainly hurtful to the petitioner, the city did not post them. And there's no proof of who actually did, which is the problem that the police department had, that the petitioner had in apparently other contexts that she was attempting to seek redress. The city of Eastport did not do that. The city of Eastport, when the disputes arose between a former counselor and her, took appropriate action and ultimately removed that person from the city council. I'm not sure what else the city could have done under the circumstances.
Right. Thank you very much. Commissioner David.
Attorney Mahar, do I understand that I want to ask you about the use of the name. Have you now published a written policy that deals with the issue, or where does that stand?
I don't believe that there's a published written policy about that, but it stands right now that the city clerk will be swearing people in using their legal names.
And by legal name, they're instructed to ask for an ID of some sort. Is that correct or not?
I don't know the answer to that, Commissioner.
You don't know? Okay. Separate question about the hearing accommodating the disability. Is there any evidence in the record of monetary cost to do what was suggested in terms of the transcription? I'm not sure I understand what technology is available for transcription. I guess you can do it live by artificial intelligence or what?
Yes, Zoom has a live transcription availability. I'm over 60, so I won't pretend to know how it works or to be able to work it. And there are other ones apparently, and
my question was there any evidence of cost, dollar cost?
The cost of the transcription of the immediate transcription with Zoom comes with the cost of Zoom, I believe. There is another one that the petitioner and the city manager have been discussing even in the last few days about that the petitioner thinks is better, and the city manager is exploring it. There may be other ones out there that we don't know about. This city does not have an IT person. It's done by whatever knowledge that is in-house or by volunteers.
Well, it sounds, how do you respond to this suggestion? It sounds like you're tacitly admitting that more needed to be done to accommodate this disability, which would support the finding, would it not? The recommendation.
I think that it does not, because technically speaking, the city of Eastport would be within its legal right to not have meetings available by Zoom and to have everybody required to be in person.
Okay.
So I don't think it is.
Thank you.
Other commissioner questions for Attorney Mahar? Seeing none, the parties. Yes. Go ahead.
Thank you. Attorney Mahar, I'd like to direct your attention to the last paragraph and correspondence you wrote to the commission dated March 7th, 2024. And it appears that this is your disagreement with the findings reflected in the investigator's report. You note in the last paragraph, third full sentence, quote, "To find the city has discriminated against anyone on the basis of disability within the definition of the MHRA does a major disservice to all municipalities and taxpayer-funded organizations of the state of Maine." That's a very broad representation, and I'd like to better understand your basis, the basis upon which you draw in support of that conclusion.
Well, I represent a number of municipalities as their general counsel. Most of those municipalities have a town meeting form of government. They do not have, some of these municipalities do not even have staff members beyond the select people and town clerks. To try to suggest that these municipalities are required to have equipment is going to be a precedent that gets set, that disrupts and changes how probably hundreds of municipalities do business.
One follow-up question as well. Attorney Mahar, you noted, I think in your opening remarks on a few occasions, you noted very specifically that none of the staff or counselors, I believe, within the city of Eastport intended to discriminate against mixed velveteen. And I'm curious about, from your perspective as a legal matter, what emphasis are you placing on the concept of intent within the context of these facts?
I'm not much at all, because the staff has tried to accommodate the petitioner's concerns and tried to get tried various experiments for public address systems and even changing location, and have been trying to make it so that they are accommodating the petitioner and anybody else with similar disabilities as the petitioner.
Any further questions for Attorney Mahar? Seeing none, the parties have used their time, so we will hear next from Investigator Brindley.
morning, everyone. My name is Alex Brindley. I was the investigator for this case. I'm not going to go in any particular order except for the notes that I have written. So first off, there seem to be a couple questions about the video regarding the sign that was on the utility pole. I mean, I think it was briefly discussed, but it was complainant's assumption that the counselor had placed the sign on the utility pole. Furthermore, complainant also stated that the chief stated it was not a crime to harass someone on that basis. The complainant, however, did provide me with an audio recording of the interaction that they had with this chief of police, and that is not what was stated. It was stated that the utility pole was essentially private property owned by the utility company and therefore was not like the placing of a sign on private property. They wouldn't have jurisdiction, or they'd have to talk to the utility company. Furthermore, and just to round off that whole thing, the complainant in this matter did not allege that the city, didn't allow the records or like destroyed the evidence because of any protected class. So I'm just going to drop that off there. Furthermore, there's no evidence that this happened because of any of complainant's protected classes. Furthermore, Mixed Velveteen stated that there was an individual who made comments about their preferred name as a quote alias. There's no record in the record that Mixed Velveteen reported this to the city in any way, and therefore would not be liable for that because they wouldn't have known. Let's see. Yeah, I think those are the main things that I wrote notes about, but I'm certainly open to any questions the commissioners may have.
Thanks, Alex. Any commissioner questions for the investigator? Okay, seeing none, we've heard from the parties and the investigator. At this time, we'd be looking for a motion. There are 3 proposed findings. Take them however you would like. Walker.
So I think I would analyze these easier because the first 2 and then the third.
Okay.
The first 2, the investigator found that there were reasonable grounds, so I will move that there are reasonable grounds to believe that the city of Eastport discriminated against Bindi Velveteen on the basis of sexual orientation or gender identity, and that there are reasonable grounds to believe the city of Eastport discriminated against Bertie Velveteen on the basis of disability. So 1 and 2, where there was a finding by the investigator of reasonable grounds, I move that we accept that.
Second.
It's been moved and seconded. Any discussion? Seeing none, the motion is to find reasonable grounds on the first 2 findings in the report. If you're in agreement, you will vote yes. Commissioner David.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
All right. Commissioner David.
I'll move that, looking at the 4th recommendation, I'll move that we find that there are no reasonable grounds to believe there was discrimination on the basis of sexual orientation or gender identity regarding the creation of hostile environment. And that that claim should be dismissed.
Second.
Then moved and seconded. Any discussion? Seeing none, the motion is to find no reasonable grounds on the hostile environment finding. If you are in agreement, you will vote yes. Commissioner David.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
Okay. So the findings are reasonable grounds on recommended finding 1 and 2, and no reasonable grounds on the third recommended finding, which is paragraph 4. We appreciate everyone's participation, and the commission will send a letter to the parties and council confirming the results of the hearings.
The second case on the agenda is E 22-140 Collins versus Atlantic Coast Towing. The recommendation is that we make a finding of no reasonable grounds, and therefore we would hear from complainant.
Mr. Collins, if you can turn on your video and unmute yourself.
One second, I'm getting some horrible echo. Sorry. I don't know what exactly
Two devices.
Yeah, okay, Mr. Collins, can you remove the second device that you're using?
I don't see a second device.
You can remove, yeah, try it. We're gonna try removing it. See if that works.
Is that better?
Bear with us.
Yeah.
Okay, let's give this a shot.
Is that working now?
Yes.
All right,
So we
sorry.
have 10 minutes. Would you like to reserve any of your time?
Yes, ma'am.
How much time would you like to reserve?
I guess however long it takes, just a few minutes. It shouldn't take long.
Okay.
Um,
Timer, go ahead whenever you're ready.
all right. I was in a hostile work environment from my boss, Chuck Louder, and other employees. I was refused the process of filing any harassment paperwork. They changed what they said in their original statement that they wrote to you guys about not knowing about the voicemail, not knowing about anything that was going on. And Chuck Louder even admitted that I had other issues with drivers. Yes.
Is that person that you've just named, is that person a party to the case? It looks like you have just named Atlantic Coast Towing as a respondent. So I'll ask you
That's the owner of Atlantic Coast Towing?
Yeah, I'll ask you not to use his name. You can just call him owner.
Okay, sorry about that. Yeah, the owner refused, yelled at me, and threatened with firing with me when I asked to file paperwork. This wasn't the first time. This was either the third or fourth time that I got into it with these employees and they refused to do anything about it. That's when they fired me. When this last investigation thing came up, they didn't actually look into anything. I asked a few questions, but they didn't look into my calls. They didn't look into what I did for work or anything else. I don't really understand how that was much of an investigation. I mean, if you guys look up all the paperwork and everything else between what I was doing for AAA and what I was doing for the company and what other employees were doing, it would be clear as day. But nothing was actually looked into. I was continually harassed and I just don't know what else to do about it. And then the fact that they fired me afterwards, and I just don't understand how any of this works. I guess that's it.
You'll have about 8.5 minutes left. Any commissioner questions for Mr. Collins? None. Attorney.
Bincheck.
Bincheck, thank you.
Yep.
Appreciate that.
No problem.
You have 10 minutes. Would you like to reserve any of your time?
No, if there's anything left over, I'll be brief. Good morning, everybody. My name is Pavel Bincheck. I'm an attorney with Bernstein Sure. I'm filling in for my colleague Tara Walker, representing Atlantic Coast Towing. This case turns really on two simple points, and I think the investigator addressed both of them. The first is that even if we take Mr. Collins's claims in his charge at face value, which there are a lot of reasons not to, right? But even if we do, they don't articulate a legal claim of retaliation. So Mr. Collins just brought up stuff about hostile work environment, none of which was involved in the charge, none of which was involved in the complaint. We're here about allegations of retaliation. And so even if we take what he said in his charge at face value, he has not engaged in protected conduct that the law protects. And that's important because the law is not there to protect every complaint someone might have about their coworker. The law is there to protect people who complain about issues relating to safety, about issues relating to discrimination. And there's just no evidence in the record that Mr. Collins did that, despite his claims to the contrary today. Now, the second issue that this case turns on is the issue of whether he was fired for any protected complaint, right? So Mr. Collins has to show that his discharge was a pretext for discrimination, and he can't do that. And the reason he can't do that, because at the base of it, violence and threats and intimidating conduct have no place in the workplace. And what the evidence in this investigation showed is that Mr. Collins came into work, he refused a work assignment, and when he didn't get the work assignment that he wanted, he became confrontational, he became physically threatening, and afterwards he was terminated. And that's a fairly valid reason to terminate somebody. Everybody's got the right to feel safe in the workplace. So even if Mr. Collins was able to meet his prima facie case, which he's not, the termination is nonetheless completely unconnected to any reports that he might have made. And so for those reasons, I would ask that the commission uphold the no probable cause finding of the investigator. Pending any questions, that's all I have.
You'll have about 7.5 minutes when we come back to you. Commissioner, questions for Attorney Binchuk? Seeing none. Oh, yeah,
Yeah, no.
Commissioner David.
Attorney Vinchek, I'm a little concerned about, I mean, I understand the argument that it doesn't fall within a retaliation. Would you, if he had gotten the, filed the complaint on the basis of hostile environment, would you still be making that argument? In other words, a pro se litigant, I believe we have to make some tolerance for the stating the correct legal grounds if we think there's discrimination.
Well, so I'll say two things. And the first is on a purely on a procedural side, right? That's not been the approach of the main courts. So the main courts hold pro se litigants to the same procedural standards that they hold to represented litigants, and basically state that a pro se is a choice. And if people make that choice, they don't get any special consideration on procedural grounds. So that's what the courts say.
He frozen.
But
Mr. There you are.
You know, that's this case. You know, the purpose of this commission is can't show discrimination. So he says the words hostile work environment. He says the words harassment today. But if you look at the facts and you look at the report of the investigator, that's not in there. One of the things, you know, that's important in this case is that Mr. Collins's claims evolve over time. What he's alleging today is not what he alleged in his complaint. And that matters, right? So while I understand the concern, I don't think that this is the case to break procedure, because the facts aren't there to warrant it.
Thank you.
Any other commissioner questions for Attorney Binchuk? None. Mr. Collins, you have 8.5 minutes if you have anything else you'd like to add.
Yeah, I'm not a lawyer. I don't know what I was doing. I thought I was getting some sort of help with all of this. That's what I was going through. I didn't know I had to get a lawyer. I didn't know I had to write anything out as a hostile work environment. I guess being threatened by my boss and by other employees, I thought that instantly just showed it was a hostile work environment. But no other paperwork was ever filed. The owner of Atlantic Coast Towing even admitted in the investigation that I had issues with the other drivers, but they had no paperwork on nothing because he doesn't do a paper trail. He refuses to. And that's exactly what I asked him to do. And that's when I got fired. They changed their statements. And I thought that was going to show too in the investigation, but nobody even said anything about that when they changed what they said. And it's because they change everything to suit their needs, to come after me when all I was doing was trying to work. And I didn't know what else to do. It's really messed up. I'm so confused. I guess that's it for now. I mean, I don't know what else to do. I mean, when my own boss threatens me and tells me he's going to fire me because all I want to do is have a safe place to work, what is my options? I mean, I thought that's what this was for. I've never had to deal with anything like this in my entire life. So I'm just completely thrown off.
Yes, if you're all set, I have a commissioner question. Commissioner David?
Mr. Collins, they say they fired you for stealing fuel and you haven't responded to that.
Well, that's what they said originally to me. And I got into it with a driver one night. So these trucks, these tow trucks, were on call 24/7. I was told I had to be in this truck for everything. If I wanted to go to dinner, if I wanted to go grocery shopping, if I wanted to do anything, when I was on call in my area, I was not allowed to leave and I had to drive this tow truck. So at nighttime between 8 and 9 o'clock, usually we slowed down. That's when I would go home, grab my kerosene jugs, and I would fill up kerosene. At the same time, I would fuel up my truck. Another driver pulled in and accused me of stealing fuel. I already showed the boss and everything else. I had a credit card receipt from what I paid for myself, and I signed a logbook for what we put into diesel. So that was supposed to be said and done with. But the other driver thought he knew what was going on, and he decided to go down to the fuel point, and he wanted to go through the book, and he was telling everybody that I was stealing fuel and I was stealing from the company, and I was refusing to do my calls, and he was going to get me kicked out of that truck. I didn't even want to be put in that truck. They moved me to that truck, and that's when all the issues really arose.
Okay, thank you.
My other thing is
Wait,
there.
Mr. Collins, no, you've answered Commissioner David's question.
Okay, sorry. I thought I had time still.
Any other commissioner questions for Mr. Collins? Seeing none, Attorney Benchek, you have 7.5 minutes if you'd like to respond to anything.
Yes, thank you. Commissioner David, I want to address the allegation that Mr. Collins was terminated for stealing fuel. Mr. Collins was not terminated for stealing fuel. I think that's fairly clear in the investigator's report and fairly clear in the facts of this record. Mr. Collins was terminated for threatening and aggressive conduct. The stealing fuel incident is separate, completely separate from what led up to Mr. Collins' termination. There was an allegation that Mr. Collins was stealing fuel because he was seen filling up non-company fuel containers at the company's fueling point. The owner looked into it and the owner didn't take any discipline, right? The owner decided that discipline was not appropriate. That had nothing to do with the termination, which was entirely linked to Mr. Collins' conduct when he would not take the work assignment that he was required to do. That's all I have. Thank you.
Any commissioner questions for Attorney Benchik? Seeing none, thank you both. We'll next hear from Investigator Morse.
Hello, my name is Angela Morse. I'm the investigator assigned to this case. I don't really have anything specific to add that wasn't in my report, although I did want to just respond to Commissioner David's line of questioning regarding the hostile work environment claim. So to, satisfy the first criteria of that claim, you would need to have the complainant alleging that he was exposed to a hostile work environment because of his inclusion in a protected class, and that was not alleged.
Any commissioner questions for the investigator?
Well,
Commissioner David.
Angela, I'm confused about the reasons for his discharge. I thought it was for the fuel, and respondent's attorney says it was not. It was for insubordination or those kinds of things.
Yeah, it was because of his work performance. There was some issues with him frequenting marijuana dispensaries on company time. There was also issues with him not getting along with coworkers. I think the straw that broke the camel's back was when he was very aggressive with the owner of the company and got in his face, and his termination occurred that day. There was also the issue when complainant got very upset because there was a lucrative job in Vermont that he really wanted to take. And the boss said that the company couldn't handle it because they were short-staffed that day. So the termination was overall poor performance, and especially that final altercation with the owner of the company.
But in any event, not a pretext.
Not for discrimination based on protected class, no.
Right. Thank you.
In my opinion, through this investigation, yes.
Any other commissioner questions for Investigator Morse? Seeing none, thank you, Angela. We've heard from the parties and the investigator. At this time, we're looking for a motion. There is one proposed funding.
I move that we accept the investigator's recommendation that there are no reasonable grounds to believe Atlantic Coast Towing retaliated against Nicholas Collins for engaging in Whistleblower Protection Act and or MHRA protected activity.
Second.
It's been moved and seconded. Is there any discussion? Seeing none, the motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner Davis.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
Right. So the findings are no reasonable grounds. We appreciate everyone's participation. The commission will send a letter to the parties and the council confirming the results of the hearing.
Next case is ED 22-0147, Jacob Clayton versus Maine Media College. The recommendation is a single finding that we find that there's no reasonable grounds, and therefore we will hear from complainant first.
Morning.
Morning. Good morning, commissioners. I'm Richard O'Mara from Murray, Plum and Murray, representing Jacob Clayton. Jacob is a queer identified transgender student, an adult student who went to the Maine Media College in Rockport virtually during the pandemic year, 20 to 21. You should be very concerned about two of the recommendations in this investigator's report. First is about the limitations period and the time bar. This is a case where quite clearly the continuing violation doctrine should apply. That doctrine says that if there's an ongoing series of discriminatory acts and at least one of the violations happens within the limitations period that anchors the claim, then all the claim is timely. And the commission's investigator is supposed to ask whether there's a substantial relationship between the allegations. And in this case, as the investigator's report says in footnote 1, the complainant made several factual allegations in the complaint that may have constituted a hostile educational environment while he was at the Maine Media College. However, none of those were considered because they were beyond the 300 days. However, when you look into the facts of this case, the 300 days may contain the period of time that Jacob attended the college. But this was not just a college that you attend. It's a professional development and career advancement opportunity for him. And there were benefits after the program. And in fact, the complaint was raised after the program was over, and it went all the way to the president. The president of the college in December received the formal complaint. This is after graduation at the end of May. So at that point, the claim would have been timely had Jacob come to the commission. The president considered this a formal complaint. And in early January, there was a conference that Jacob attended with the president. The president told him at the time, this is a serious complaint. I'm going to look into this. I need your patience, he said. He wrote to him, it's the emails in the record, I need your patience in advance of our next discussion. And he said, I'll be writing to you more as things progress in the investigation. So all of the complaint was before the college's highest officer in December and January after the graduation in May. And then nothing happened. Nothing. No response at all from the college for weeks and months. Jacob became concerned and finally got a lawyer to file. By the time he filed with the commission, it was outside the 300 days from his graduation. However, the complaint that went to the president never got addressed. So what happened? We don't really know because there was no fact finding in this case. No one was ever interviewed as to what really went on. But when you look at the report, the second most troubling thing, apart from the lack of the continuing violation doctrine, is the total giving a pass to the president of this college. The president says, apparently, that the reason that the entire investigation was dropped without even saying it was denied or rejected, it just was silence. And the reason for that was that he was concerned that when Jacob had a run-in with the provost and had written unkind emails and texts to the provost, the president didn't want Jacob to do that to him. So he just stopped the process, stopped investigating, even though in the meeting he had with Jacob, he said it was a serious complaint, serious allegations that needed to be addressed, and that he would take this into account and write more as things progress. So this turned out to be a great stall tactic because it actually made the allegations of the complaint fall outside the 300 days, and the commission should not be rewarding that. The event that anchors this, as the courts say, in the 300 days is the fact that the president accepted a formal complaint, promised to work on that complaint, to keep the complainant apprised of what was going on, and then completely went silent for no good reason. And I submit to you that if the commission is going to allow investigators, presidents of institutions, employers to do this to complainants, to basically say, yes, I'm accepting your complaint, I'm going to investigate, please be patient. And then they just do nothing. And then come back and say, gotcha, your complaint's too late to the commission because we just made you wait and wait and wait. That is going to be unfair. That's what the continuing violation doctrine is for. Jacob filed this within 300 days of the formal complaint being passed on by the college. And that should be enough. And so on the merits, we should be able to look back at the entire year that Jacob spent in this program. And that year is filled with a series of incidents that are not really recounted in the report that you have, which involve preferential treatment for the cisgendered students at the school, total marginalization of Jacob as a transgender student. And if you would look at that, there is reasonable grounds for this case to go forward and to think that there's at least an even chance that he would prevail before court. Unfortunately, the report that you have basically minimizes everything that happened before that and then gives the president a pass on doing absolutely nothing with the formal complaint that was presented to the college. And I'll reserve the rest of my time unless there's questions now.
Any questions for Attorney O'Mara? Excuse me.
Thank you for that. Curious about your assertion that the president didn't do anything with the complaint, therefore delayed, and therefore the complainant missed their window of time. Doesn't that ignore, though, the fact that at the same time as the complaint was pending with the college, the complainant also could have availed themselves of the opportunity or option to simultaneously file with the commission, correct?
I agree that the complainant, had he known, he didn't know at the time about the commission process. He found about that after he got suspicious about the president taking so long. But I agree he could have filed during that time period. But we should be encouraging people when they're in an institution like this to file their complaint internally first. It happens routinely. And to expect that at least you're going to get a yes or a no and not just a nothing. That's my point here. You shouldn't have radio silence, leaving somebody totally at sea about whether the complaint's being resolved, looked into or not. And eventually, as you can see how the clock runs, when you're waiting and someone says, have patience, that's what I'm most concerned about in this case. You can't just tell somebody to have patience knowing that the clock is running on their claim.
And quick follow-up question too, and this may be better directed to the investigators, so you let me know if you'd like to handle it or not. Do I understand, I think what I heard you say is that after the complainant initiated their complaint with the president, did the president actually conduct an investigation and issue findings in support of whatever the result was?
There was an initial conference where the written complaint was presented and they had an initial conference about the allegations. And then that's when the email came afterwards saying, now have patience. We have your allegations. We'll be looking into them. We'll keep you apprised as things progress. And that's where it ended. So there's no findings. It's just the allegations.
Any other commissioner questions for Attorney O'Mara?
Thank you.
None. You'll have about 4 minutes when I come back to you. Attorney Pitney, 10 minutes. Would you like to reserve any of your time?
Yes, I will, but I think I'll probably cut myself off well before 10 minutes. Good morning, everyone. Thank you. Good morning, everyone. My name is Julia Pitney, and I'm here on behalf of Maine Media College in support of the investigators' recommended finding that there was no reasonable grounds to issue a finding of discrimination in this case. Attorney O'Mara raises a point that he stressed in his submission on the 300-day look-back period that bears obviously careful consideration here. The reason that the continuing violation doctrine does not apply here is because, first of all, looking beyond the 300 days, which the commission is statutorily not supposed to do in any case, there is no direct evidence of discrimination based on Mr. Clayton's status as a transgender man anywhere in the record. The investigator did look into some of the previous allegations and addressed those in the report, and determined that several of these allegations, one having to do with promotion of another student or 2 other students' materials, was not related to his status as a transgender man. Secondly, there was no evidence in the record showing that Mr. Clayton had applied for or been denied enrollment in any postgraduate programming. I can't stress enough as well, and I think it's pretty much highlighted in the report, that this is an extremely small program. There were only 4 students in the program. At its max, it would be capped at 8 students. So I just want to be clear that when we're talking about the universe of students, it's really quite small, which I think is important. With respect to the complaint process with the president, Mr. Clayton graduated in May. His complaint to the president was not filed until December 16th, which was a day after, and I guess within 48 hours of having an escalation with the provost that was, hundreds of text messages were submitted to the investigator. The investigator quoted a number of them. To say that it was a negative encounter, as Attorney O'Mara characterized it, is simply stretches beyond the imagination's bound. The timeliness of Mr. Clayton's perceived personal rejection by the provost, who was attempting to distance herself following a Thanksgiving gathering, and after which she felt he was inappropriately attached to her, then went to this Catalyst event where he had invited her and her husband for Christmas Eve dinner, and she hadn't responded yet. And he simply, I don't think it's an unfair characterization to say that, incredibly escalated in tenor and vocabulary and tone. specifically, there were threats against the school, threats to, essentially take down the provost. So that cannot be ignored, as the investigator noted. I mean, the motivation for then filing a complaint with the president the next day is absolutely, that temporal connection can't be understated. So to say that Mr. Clayton didn't understand the Maine human rights process or whatever at that time, and that's the reason for the delay in filing or bringing a complaint first to the president and then filing with the commission, is, I think, not supported by the facts in the record. The president, and there is a typographical error in the investigator's report. There's some conflation of provost and president. The president's submission, the college's submission, said that the president did not initiate additional contact because he did not want to provoke similar behavior directed at the provost or others. He did not say at him. So I think that's actually, there's a provost president typo in there. And I think that's important as well, because once the text messages were brought to light to the president after this complaint was filed, it became clear to the president that the situation was not simply a student making a grievance. This was a much bigger issue involving a former student, sort of threats and I guess allegations and behavior towards an employee. So to say that nothing was done or there was no response, I don't think is accurate. But even still, I think that the fact that the timing of the complaint with respect to the relationship explosion, if you will, with the provost, can't be understated, and simply can't be it breaks the connection that would be required for the continuing violation doctrine. I'll reserve whatever other time I have, or if you have any questions, take those.
About 4.5 minutes. Any commissioner questions for Attorney Binney? Seeing none. We'll come back to Attorney O'Mara. You have about 4 minutes left.
Thank you. In reply to those points, let me just say this. There were only 4 students in this program during the pandemic. That's a given. However, the differential treatment of the transgender student still is relevant. And there was a lot of evidence about the way he was treated, marginalized during the program as compared to the others. You don't need to have many students, just need to have enough to show differential treatment for discrimination. On the bit about the president, whether the president was concerned about the emails to the provost, who knows? We never had a fact finding. All I'm telling you is that in this case, Jacob brought his complaint first to the provost in April while he was still a student. The provost took measures into her own hands. It's in the record. She helped him finish the program because he was ready to quit in April, given the treatment that he was facing. She got him to the finish line to graduate with a lot of one-on-one attention. He then found out, as their relationship continued over the summer, and felt double-crossed by the provost. That in fact, she hadn't told anybody about his complaint, and that she had sort of massaged him through the program and out, and there was a breakup in their relationship in December, no doubt about that. And it was a long series of texts in the record. We're not denying that. It's an emotional breakup. He had thought she was helping him. He then realized, in fact, she was essentially marginalizing him again by getting him through the program, but he wasn't getting any of the benefits of the program, which are supposed to be highlighting student work, putting them out into their careers as photographers, and that none of that was happening for him. He was being marginalized again, essentially silenced through her treatment. That's when he went to the president. So when he goes to the president and they have the sit down, you have to ask yourself, doesn't the president at least owe him a reply after telling him, be patient, these are serious allegations, I'm looking into them, be patient, I'll write to you again as we progress. That's the email, the last email, and then silence. It's not that the president just said, I'm not gonna process your complaint. You have other remedies, go do it. He just was silent. That's a huge concern on this record. I think the commission should be worried about the precedent this is setting. This is the way we're gonna treat people who come forward with a complaint against an institution saying, I've been discriminated. That's all I have for rebuttal, but I'm happy to take other questions.
Commissioner David.
Attorney O'Mara, how can we not ignore Attorney Pitney's pointing out that the president, that the complaint comes the day after the provost cutting off the relationship and the president finding out about it in the context of him graduating in May and then waiting in December? That can't be a coincidence, can it? That he files a complaint that's not, the obvious implication is that that's retaliatory for what the provost ending the relationship.
No, it's not retaliation, Commissioner. What that is a realization of what has really happened, right? Up until then, I think Jacob viewed the provost as someone who was an ally, who had helped him through the program at a very difficult time when he was ready to quit in April, got him to graduation, and was going to keep working with him and helping him receive the benefits of the program, the career advancement. And he realized in December that in fact that was all a ruse. And that was, again, part of his complaint, that he'd been marginalized not only by his teachers in the program during the school year, but also now by the provost after the school year had ended. And the provost, and it's in the record too, was married to the person who was the gatekeeper, the MFA program there. And there were promises made to him that he would be a candidate for that. Eventually, they would help him get into that program. And that was all lost. And then when he realized none of that was going to happen, that's when he brought his complaint to the president. And that was a timely complaint to the president. No question about that. And then it was dropped. I think you also see in the record, the president doesn't say anything when he meets with Jacob saying, this is too late, this is all done. No, the president said, these are serious allegations we need to look into. Be patient.
Thank you.
Any other questions for Attorney O'Mara?
Thank you.
Hearing none, thank you. Attorney Pitney, you have about 4.5 minutes left.
Thank you. Just in response, the allegation that Mr. Clayton made a complaint to the provost back in April is not supported in the record, in the sense that he did not make an allegation that he was being treated differently because he was a transgender man. There were certainly allegations that he felt that another student particularly was being or being shown as a favorite of the professors in terms of promotion of work, but it was never alleged that it was because he was a transgender man. The breakup characterization by Attorney O'Mara, I think, is also a little bit of a stretch. These text messages that were submitted to the investigator is not a back and forth between the provost and Mr. Clayton. There were literally over 100 texts. I mean, I think her only texts back are, please stop, I'm going to call the police. You know, I mean, it goes on and on and on. So I just want to make sure that can't be understated. The MFA program, and so, sorry, to circle back, that's not a coincidence in terms of the timing. The MFA program, as Mr. Clayton acknowledged in his submissions, he was not a candidate for the MFA program because he did not have an undergraduate degree, except in this sort of, they would take 1%, or excuse me, 5%, which amounted to one student, they would allow who didn't have an undergraduate degree. Mr. Clayton was aware of that when back in the fall of the program and knew that. So to say that, other students were admitted to the program after and he wasn't, number one, he didn't apply. Number two, the other two students that did were had the other qualifications to get in, presumably undergraduate degree. There's one student that was admitted to the MFA. Another student from his program did some follow-up programming. But again, Mr. Clayton never applied, never asked for financial assistance or anything. So to say that he was not helped to get into this MFA program, I think is not supported at all in the record because A, he didn't apply, and B, he knew months before he wouldn't have been eligible for several years. I'll take any other questions and if there are any.
Yes, thank you. One question, Attorney Pitney. Did the president and or the college itself in fact investigate Mr. Clayton's complaint?
Well, so the president, they have a committee that that meets monthly. The complaint was, and I think this is in our last submission, was submitted to the committee. But at the same time, because of the allegations, or excuse me, the context around the threats to the school and the tones of the text messages, I think the college was much more focused on the fact that they had someone who had made threats against the school, had made threats against the provost, and had specifically made threats against this accreditation process. So was there a formal investigation that was ultimately, conducted to the very end? Mr. Clayton then filed his complaint with the Maine Human Rights Commission and sent a letter from his attorney. So it didn't run its course in that sense.
Okay, thank you. So in other words, the college itself did not conduct an investigation nor draw findings or conclusions of its own in the context of Mr. Clayton's complaint, right?
Not that I'm aware of.
Okay, thank you.
Any other commissioner questions for Attorney Pitney? Seeing none, we've heard from the parties and we'll next hear from Colin Hurd, who investigated this.
Good morning, commissioners. So you know, my name is Colin Hurd. I was the investigator for this case. It's nice to see you all in person. Usually I'm on the screen. A couple things. One thing that the respondent's attorney already addressed, but I wanted to make sure that I addressed was a correction in the report itself. So that would be paragraph 9C of the analysis. So there was a mistake there with that I made with the names for provost and president. So what it should read as is, this is the last sentence of that paragraph. It was only when president learned of complainant's aggressive text messages to provost that he chose not to initiate additional contact with complainant because he did not want to provoke similar behavior directed at provost, not at him. And I just wanted to point out too that that is reflected elsewhere in the report, footnote 3, which is the last footnote regarding the facts of the case, which highlights a response that respondent made to an RFI, where they said that, president had intended to update complainant's plans progressed if complainant had inquired, but he decided not to initiate further contact with complainant after provost revealed to him the text messages complainant had sent in mid-December 2021. Respondent stated that the president was concerned that further communication might trigger similar behavior toward provost. I guess that's really all I have. The rest of the report, I think, stands for itself. Respondent addressed a lot of things that I was going to address. One thing I do want to point out is the events before the 300-day jurisdiction. So it does say in the footnote, they may have constituted a hostile educational environment, but the reason I used the word may there is because they weren't actually analyzed in this report. I'm happy to, I guess I should defer to Barbara on this. I'm happy to talk about what was alleged before that 300-day jurisdiction. But I will say from the outset, I don't think that those rose to the level of a hostile educational environment either. Also, I wanted to point out that respondents' characterization of the text messages are correct. I thought about using them or including them as an appendix for you all, but it was pages long and it would have dwarfed the report itself. But the highlights that I've included in the report are very accurate. And that's all I had. Happy to answer your questions you have.
Okay, so in the report, in the record, here's what I see, right? I see the allegation about the MFA program, right? I see the allegation about the promotional video, like it being excluded and, that not being put on the website gallery. And then we've heard from Attorney O'Meara about sort of how the complainant was sort of excluded from all the benefits of the program, let's put it that way. With respect to the allegations prior to the jurisdictional period, I mean, what can you tell us about those if Commission Counsel doesn't mind elucidating? And I think in light of the arguments that are being raised here, I think it'd be helpful for us to hear those.
Yeah, absolutely. So the majority of those allegations are regarding, so there's the work of one student that's been referred to a few times as sort of like a favorite student. His work was promoted a lot more than the other students. I believe that one of the projects he did involved a transgender prostitute. I can't remember the country, but from a different country. And I think that complainant was upset about that because I think complainant intended to do something along those lines and felt like he couldn't do that now that this other student had done it. There were some other similar allegations regarding, I guess I wouldn't use exclusion is not the right word, but not feeling like he was getting the same attention maybe or promotion as these two other students. As respondent brought up in her presentation, I think the impression I got from the emails and the messages that are all on the record that I read was that his complaints about those were mostly based on non-inclusion. He didn't specifically raise that he felt those were based on his protected class. There is one incident that was concerning to me that involved I think it was a TA. So this is going on during the pandemic, excuse me. So these are online classes. During one of the classes, a TA was messaging the complainant and asking very inappropriate questions about complainant's transgender status. That, as far as the record shows, the complainant never raised that issue with anyone, didn't file a complaint, didn't bring any attention to it. Obviously, it's very unacceptable behavior, but I mean, respondent couldn't really do anything about it because they didn't know about it. And I think that basically sums up.
With respect to the allegations about complainant not getting similar attention as these two other students prior to the jurisdictional period, did you make any findings as to whether or not that was true, whether or not there was a different reason for that, or as you did with some of the allegations within the jurisdictional period?
I think so. So what I have is an admission in some of the emails from the professors, or maybe it was I can't remember exactly who it was, saying that you're right. Like we've only included, so there's 4 students in this program. We've only been promoting the work of 2 of them, really, and we've left these other 2 out. One of them was complainant, and one of them was another student. I'm sorry, could you repeat your question? I think I started answering.
You're on the right line. Yeah. What I'm basically wondering is there any evidence in the record as to why this purported lack of attention occurred? And you were answering that question.
Okay, yeah, I don't think it was motivated by anything. I think they were just perhaps not doing their due diligence to be inclusive. But I don't think that they were intending to not include complainant for any particular reason. I think these particular students, they really liked their work and they were very excited about it. And then they just kind of neglected the other 2.
Thank
you. Yes. Did you in fact have an opportunity to interview the president in force of your investigation?
I did not interview the president. I believe that, based on the information I had, there was quite a bit of emails and messages that I read through, that what I had was sufficient to reach a conclusion. I did request information and documents. I got written submissions from them, but I did not do official interviews. But
any other commissioner questions for? Seeing none, thank you, Colin. You've heard from the parties and the investigator. At this time, we'd be looking for a motion. There is one proposed topic. Yes, Commissioner David, you're muted.
Thank you. I'll move, we find that there are no reasonable grounds to believe that respondent discriminated against complainant on the basis of sexual orientation or gender identity, and the complaint should be dismissed.
Second.
Been moved and seconded. Any discussion? Being none, the motion is to find no reasonable grounds. If you are in agreement, you'll vote yes. Commissioner David,
Yes.
Commissioner Douglas,
Yes.
Commissioner Walker,
Yes.
Commissioner Sanders.
Yes.
Okay. So the findings are no reasonable grounds. We appreciate everyone's participation, and the commission will send a letter to the parties and the council confirming the results of the hearing. Ed, could we take a 5-minute break?
Sure, absolutely. We'll be in recess for 5 minutes. Okay. We all set? The next case is E220125, Billy Sue Ham versus Pratt and Whitney. Recommendation is on 2 counts for no reasonable grounds and 1 for reasonable grounds. We'll take the no reasonable grounds since there are 2 of them, and hear from complainant.
There hasn't been a submission of disagreement for the reasonable grounds findings, so we would start with the complainant anyway.
Oh, I see. Okay. All right.
Right. Ms. Ham, you have 10 minutes. Would you like to reserve any of your time?
Probably not.
All right, whenever you're ready, go ahead.
I'd just like to say that I appreciate the commissioner, Mr. Colin Hurd over there. I agree with the disability discrimination. I disagree with the rest of it. I feel that there is more than enough physical evidence that is in there. If this goes further, I'm prepared, I'm ready, but I will take whatever you folks tell me today as a recommendation. Thank you. That's it.
Okay. You may win the record for briefest presentation to the commission ever, so we appreciate
I feel
that.
like I should have won.
I will ask, do the commissioners have any questions for Ms. Ham? Seeing none, you will have 9.5 minutes when we come back to you.
Thank you so much.
Yeah, I actually,
okay.
All right. A little bit late. I was just looking for.
No.
Thank you for coming. First of all, appreciate it. I'm curious about, there's a piece in the investigator's report that lays out the, so you were placed out on fitness for duty, to, you know, a process that you engaged in psychotherapy, had medical appointments, and, you know, we're working closely with a counselor. Did, as I understand it, the cost of those medical appointments, did you bear those yourself? Did the company ever offer to reimburse you for those medical costs?
They flat out in an email told me it was all at my own expense.
Attorney Chomiak, we will hear from you just in response to complainant submission, since respondent did not make a submission of disagreement with the report.
We did make a response and we did submit something, your commissioner. It was emailed back on the due date.
Excuse me. I hate to root for the other team, but I did get hers.
You received it?
I did.
The commission did not.
I received hers. I don't need to root for the other team.
Yes.
Thank you, Ms. Ham.
You're welcome.
It was emailed along with the instructions on where to email it to. I believe it was due on the 1st, if I remember. It was submitted the Thursday before the Friday that it was due on.
It was due on the
copied it.
15th and I got it on Thursday, the 14th.
Yes, thank you, Ms. Ham.
You're welcome.
And we copied Ms. Ham on it.
Chelsea, have you seen it? Colin, can you go back through your email?
Yeah, I looked already.
Colin doesn't have it.
It's not in Civi either. I just have the complainants and Collins. No redactions for them. Email. Who gets those emails? You do, right, Chelsea?
Well, sometimes they come to me, I don't have anything. Sometimes, and I would have had it in my inbox if it had gone to the info at.
Yeah.
The email we sent it to was the info@mhrc.maine.gov.
Brett gets those if you want to have them. I think running the meeting. What was the date again? I'm sorry, just so that I can narrow Brittany's focus.
March 14th.
March 14th was the day, and you got it by email? Okay, thank you.
I'm looking to see if I can see if it was returned or anything in my emails. I don't see that. I didn't get a notice that it didn't go through.
I do have it in the info at inbox. So I'm not sure why those come to my email address also, as well as Brittany's. I don't know. Is that the day of the snowstorm? I have the 14th is in my head for something. I'm not sure why.
No, I don't think.
No, I was, no. Well. Wait for Barbara to come back. Um,
So there is a suspicion, there is a submission.
There is a
Object,
submission, yes, which we only just became aware of about 3 minutes ago.
I think we should continue the case.
Yeah, yeah, I think you're probably right. I will. Do you want me to forward this to all of you, or do you want me to upload it to OneDrive for the next meeting?
I'm gonna move that we continue the case and
Yeah.
treat it in a orderly fashion when we all have a
But-
chance to look at it.
Yeah, okay, I'll add it to that. What I was asking it is, do you want it now for
No.
your consideration going, or I'll add it to OneDrive for the next meeting?
Yeah, that would be, yes, I don't want to get confused.
No worries, I have it.
I know, I heard. Or an alternative, I'm mindful that Ms. Ham joined us today, not understanding what her scheduling restraints are. Is it something we could schedule for the afternoon?
So the submission of disagreement is 4 pages long.
Right.
If we take a
Over
lunch
lunch.
break and you all are comfortable reading it over the lunch break, we could hear it this afternoon. Ms. Ham, would you be able to stay for a couple of hours?
Whatever needs to be done, if you need to reschedule when I come back, that's fine as well.
Okay.
I'll make it work.
Up to you then.
I can't do that, Kit.
Oh, because you've got
Right.
a 1:40, right, okay. So Ms. Ham, I do apologize, and Attorney Chomiak, I apologize to you as well. If you are free to come back for the May meeting, we will reschedule it for then.
Okay.
Okay, great, thank you, and again, I apologize. I will make sure that everybody has the submission. I'm downloading it right now.
Will we receive notice for the May hearing as well?
You will,
Yes.
yes.
Thank
We'll
you.
make sure you're added to the list, so
Yes.
you'll get the Zoom
What is it
link.
about? Do you want me to review it?
Yeah.
Do you know what the date is for the meeting?
The 6th, May 6th.
May 6th? Okay.
Okay,
Are we free to go?
you are free to go, yes, thank you. All right, thank you all for coming.
Thank you.
We're all on board next time. Thank you so much.
Yeah,
Thank you.
apologies, I'm gonna go ahead and blame this on the eclipse.
That's why the eclipse, that's where we're going.
All right, so we will hear that one next month.
So the next cases are the ones that we're taking together, right?
Yes.
Against the town of Scarborough, they're H 220433, 0434, and 0435. And the recommendation is for findings of no reasonable grounds, and they're all the same, correct? So we would hear from complainant.
Everyone's in. Oh.
Are the complainants on?
Oh.
Frank Alessandro may be joining. Are we expecting the complainants themselves in any? Okay.
No.
I don't see Frank on this.
No, we had to cover a hearing this morning unexpectedly, so it was just.
All right. Attorney Neal, you have 10 minutes. Would you like to reserve any of your time?
I would like to reserve 3, please. Thank you.
Ready?
Good morning, Commissioners. I'm Alice Neal. I represent Ty Brown, Stanford Ellis, and Corey Mitchell. They are 3 complainants who were residents of the town of Scarborough. And I know that there are a lot of facts that have already been in the report. So there are some things that I just want to try and focus on to frame this in terms of the recommendation of the investigator. And one of those initial things that I would like to point your attention to is that the investigator has said that these cases this is definitely a housing case. All 3 of these individuals were tenants at the motel using emergency rental assistance funds while they were residents of the motel. And that is by virtue of just where they were living at the time. by virtue of the town's actions and the town acting as a gatekeeper, all of them were ousted from the town. And they were no longer able to have a place to potentially reside within the town. And by that, I mean maybe a shelter, maybe be able to do camping or things like that. The zoning ordinance of the town specifically do not allow for a shelter. I know that there's been a footnote in the beginning of the report about the fact that no one made an application on behalf of anyone to do a shelter in the town. However, if you look through the zoning ordinances that are provided as part of the investigation, none of the ordinances allow for in the residential zones for a building that is considered to be a shelter of any kind. There are potentially places that could be a charitable organization or a nursing home or hospice, but there's nothing that accounts for in a residential zone for there to be a shelter. Temporary housing as defined under the town ordinances is for the intent is for an RV, a mobile home, or some temporary shelter that is built on the premises or erected on the premises where someone is already a permanent resident for them to be able to just fix their home while it's had some kind of natural disaster. And so it does not allow for, the town does not allow for a shelter. The town's actions by then not renewing the license of motel made it so that a town where there's already only 1% of that town at the time the census was done, who were Black or brown, were no longer able to live there. The residents, all of my clients, and about 18% of the residents at the motel were Black or brown individuals, were then no longer able to stay or choose to stay as residents of the town of Scarborough because they had no place to go within the town of Scarborough that would be a temporary shelter for them to be able to live. It's been this classic idea of, well, there's Portland, go to Portland. And you see this in a lot of towns. It's, oh no, not here, go to Portland. We don't want to have certain people here, whether they be Black or brown or low income. And you can see a lot of that happening within the state, and that's not in the record, but that's just public news. So with my clients, one thing that I think is important for the commission to keep in mind is that the housing regulations give a different idea of how the housing statute should be looked at, and not such a narrow construction as the definition of what a housing provider is. The housing regulations 801C says that consistent with public policy underlying the act and with firmly established principles for the interpretation of such humanitarian legislation, the remedial provisions of the act shall be given broad construction and its exceptions shall be construed narrowly. And further, the regulations, and one of the claims that was argued both in the submissions but not addressed in the complaint in the analysis of the report, is a claim for perpetuation of segregation. And so one of the claims that was not analyzed entirely was the idea that the town's ordinances, the enforcement of the ordinances, and the lack of the ability to have a shelter within the ordinances perpetuate segregation within the town of Scarborough. And there was factual data that was given both with, I know there were a lot of exhibits with the submission of this agreement. There was an affidavit from an expert. There was other information that was given with each of the rebuttals that also recounts what this factual data is about the number of residents within the town of Scarborough who are Black or brown, and the disproportionate, the easiest number to remember is the 1%. 1% of Scarborough is Black or brown at the time the census was done. And almost 18% of the residents of this motel were Black or brown. And the town, by using its ordinances that say there's no shelter, doesn't allow for a shelter, then the people who were being displaced from the motel when they took steps to not renew the ordinance, or not to renew the license, I should say, that they were then excluded from being able to choose to continue to stay in Scarborough. They can go to a shelter. They couldn't camp. There was nowhere for them to be able to go with their rental assistance funds. There was nowhere for them to shelter themselves and remain residents of the town of Scarborough. They didn't have a shelter that they could go to. The ordinances did not provide for one. And so when I talk about the perpetuation of segregation claim, I'm specifically also looking at the ordinances that are referenced within the commission's housing regulations that say that it shall be unlawful because of protected class status to engage in any conduct related to the provision of housing or services and facilities in connection therewith that otherwise make unavailable or denies dwellings to persons by, and this is from the regs, employing codes or other devices to segregate or reject the applicant or refusing to provide municipal services. So here we have the town that is in effect segregating its population, saying you can't stay here. We're going to not renew this license. And yes, there may have been concerns that have been raised that are in some ways stereotypical about Black or brown people, or people within the community who have come to town meetings who have said that there are concerns about needles or other things that might be related to mental health. But those are concerns that are raised that, yes, they may be there. There were increased calls to emergency services. Anecdotally, it is not known that those calls were made or were referenced to Black or brown tenants who were in the building, but to the tenants as a whole. In fact, one of the things that we argued as part of the case that was not raised was the disparate impact analysis, is that we did provide a less restrictive means that could have happened in terms of being able to achieve a different goal, and that would be to evict the problem tenants, not all of the tenants. Instead, the agreement the town came to with Motel was that every resident who was a recipient of the public assistance benefits was evicted. And I understand that's probably my time, so I will stop. So I have some. You take any questions?
Any questions for Attorney Neal?
Yes.
Okay, Commissioner Davis?
Yeah, Attorney Neal, whose money is the emergency assistance coming from? Is that federal money?
That was, I have to go back and look. I believe it was a combination of state and federal.
Okay, and it's coming to the town?
No, it was being paid by a different agency that's just called agency, or I can't remember the name that lead investigator Riley used in her report, but it was a different agency that was paying the rent for my client.
So the agency is administering the funds, the town's not doing that, they're paying the motel, and then that program ends, is that correct?
What happened is they were all tenants at the motel was being paid rent. The town's role in this is that on an annual basis, the town had to do a renewal of the license for the motel.
Right.
And so given the increased calls to public service and other emergency service issues, this is the argument is that the town said that for the motels that had increased number of calls over a certain threshold, then those would not have an automatic renewal of their license and they had to go through a longer process, which fell to motel where my clients were staying. And so then they had to go through a longer process. And I'm trying to be very careful not to use names or say anything that wasn't in the record. So lead investigator Riley, please correct me if I have gone astray.
Well, your allegation is that the town is that's a bad faith overly stringent renewal of the license in order to deny it, in order to get rid of those tenants, right?
That was part of it, but we did it as not in that line of the denial of the license, because our clients had housing made unavailable when the town was going through the process of not allowing for the renewal of the license. There was a series of negotiations about what would happen in terms of the renewal of the license. And so there were some conditions that were put by the town on the motel.
At some point, the money dries up, right? The program ends.
Still there, even after the money was there. I'm trying to be really careful because there are more facts that were not in the record about after, because this case took a while.
What would you say to the assertion that the town's failure to have a zoning ordinance that allows for a homeless shelter, you say that I mean, it seems like that might need to be a legislative solution if you're thinking that that's discriminatory.
Well, and that's where I think that municipalities have their own ordinances, and I'm not sure what the town of Scarborough would say about what needs to happen to change their own ordinances. But I do believe that is something that, my argument is that the town's ordinances themselves, by not allowing for a shelter, perpetuate segregation. because of the already very white population of the town of Scarborough and my clients who are Black and brown people.
Right, and that's a fairly broad holding that would come out of this finding, as it were, that we're saying that the town's failure to have that in its ordinance, we're going to find is unlawful discrimination, right? Isn't that what you're asking us to do?
I am in part, yes, because
Yeah.
because the commission has the ability to look at ordinances and look at how municipal organizations and are working with individuals, and the commission is vested with preventing discrimination across the state. And if the town's ordinances prevent the ability to allow for a diverse population within their own ordinances, and they were actively taking steps to get rid of this population of people, then I believe the commission can find that based on the even chance standard that discrimination did occur.
Okay, thank you.
Commissioner Douglas and Commissioner.
Just a little bit. You said me first.
I did, yep.
Monday. I just want to be clear about how this program, how your client's tenancy terminate, right? Because I'm looking at the report and it talks about this September 21st, 2022 meeting, right? Where the conditions I thought I just heard you refer to were implemented, right?
Mm-hmm.
Continued on-site security, continued on-site licensed social services, et cetera, et cetera. And then there was, there was this condition that if the plan was not fully implemented by the end of the year, the town manager would schedule replication.
Mm-hmm.
What am I missing here? Is that it, or is there more to the story?
After that hearing, the motel took steps to serve the tenants with a series of eviction dates in court. And so two of the clients, Mr. Brown and Mr. Ellis, were served with and had eviction dates while this case was pending and the record was open. The third client, Corey Mitchell, was still a resident at the motel that entire time. And there were still emergency rental assistance funds that were available, and they even got extended past the original deadline.
Right, but that's the motel, right? The motel's not a party.
The motel is not a party.
And then my other question had to do with these safety concerns. I read in the record, you know, that the town is claiming there are all these increased calls, right? And as you so eloquently stated, all the stereotypical sort of reasons were thrown out there: needles and drug use and crime and all these sorts of things. I thought there was a distinction somewhere between, well, let me ask it differently. Were there regular sort of motel renters at the same time as these other folks that you represent? I mean, were there people just coming and renting a room for a night or two and then leaving?
Everyone at the motel at that point was a part of the emergency rental assistance program.
And do we have any sense as to whether or not these safety concerns were in fact substantiated in any way, or do we just have the stats?
They were, we have the stats. There were calls to public safety, and the town provided those. There was not a delineation in the stats provided by the town to distinguish between people of different race or color who were committing the crimes that were reported.
All right, so just coming back to my other point then about the town versus the motel, right? So the town says we'll approve the renewal of this license, right? You just said there were still funds available, and the motel starts evicting people. So then I know maybe this is overly simplistic, right? But how is the town responsible?
The town wouldn't enter into the agreement to be able to allow them to continue to operate if they didn't make a plan to evict everyone who was a recipient of who was a recipient of the emergency rental assistance benefits. So the agreement between the town and the motel is that there was a rolling eviction of every single individual in the motel. And so those people ended up with different dates in court over time.
Okay, thank you for now.
Commissioner Walker.
I kind of like the way you phrased this, that you use the term Scarborough town would have to intentionally pass ordinances that result in discrimination. Are you saying that over a period of time, as Scarborough passed these various ordinances, that they had to do it intentionally?
No, that was not my intent. That's what I said.
So,
Yeah.
yeah, spin that up.
Yeah, so I do not have the history in front of me to tell you when these statutes were enacted. I believe that might be in the end of each one of them in front of you, but I have not in preparation for today gone back and read each one of those to tell you when they were done. So I don't know when they were.
My guess is though, that they were not done all at the same time.
That is an assumption that I can't yet, and I don't know that I know it's in the record in terms of the dates, but I don't want to misstate it.
So, but I guess my question would be as to, in order to find discrimination, do they need to do it intentionally or not?
I don't believe they do, and that's the purpose of the disparate impact claim.
Okay, all right, so follow up. I take it from the way of making the argument that the actual failure of the motel to have the safety in place or those problems, that by itself wouldn't necessarily be the discrimination. The discrimination is that the town has no alternative once that occurs. So the licensing of the motel isn't the critical point.
The licensing of the motel isn't the critical point. The critical point are the town's actions, and where these residents who were residents of the town of Scarborough then had no place they could go, no place that they could choose to remain within the town of Scarborough if they wanted to on a temporary basis. They didn't allow it because of the lack of shelter. The ordinances, the residential zoning ordinances themselves don't even contemplate a shelter. Then there would be no place for these ousted residents to go except go to Portland. Don't stay here.
Okay.
I'll stop. I know I'm.
Commissioner Sanders.
Thank you. In follow up to that question, I'll pick up where you left off. I'm curious, are you telling us that every municipality in the state of Maine must have a zoning framework that contemplates that a shelter could be sited within that municipality? Is that what you're telling us?
That is not what I'm saying with the particular case, because I am saying based on my clients and their acts. So I'm trying not to go outside of the scope of what the case is, so I can't say what every town should do. What we have is that in this case, this town has ordinances that don't allow for the shelter, don't allow for a place for people to go.
That's right.
Yeah.
Okay. All right. And then to sort of dig into a previous representation you made, Attorney Neal, would we be here today if, to your point, instead of evicting all, the motel and the town worked together to lay out a strategy that only those tenants engaged in problematic behavior would be evicted?
Don't believe I can appropriately answer your question because the household isn't on the record. That would be where I would go with that, but I don't believe that's something that I should appropriately answer given the commission's process.
Any other commissioner questions for Attorney Neal? Are you sure?
We're resting now.
Okay. Attorney Neal, you'll have 3 minutes when we come back. Attorney Brogan.
Thank you.
You have 10 minutes. Would you like to reserve any of your time?
I had 2 minutes, please. So, I'm fascinated actually by the arguments being made because the facts don't support it. What happened here is what the investigator found. And so all of you know, I mean, this case was thoroughly investigated by a very smart investigator and properly analyzed as far as the law is concerned. There's no evidence, none at all, that race played any role in what was going on here. And in fact, the investigator found this. There's also no evidence that the fact that these 3 individuals were receiving housing assistance played any role. What we do know is that there's a crisis out there, and the crisis involves the people who are both unhoused and don't have alternate shelter. The issue about the no shelter in town, No one's asked for a shelter in town. There's no evidence been presented that was ever asked for a shelter in town. They could move for a conditional use, they could move for a variance, there are a variety of ways to do that. They didn't, none of that's happened. None of that's in the record. What has happened and what Investigator O'Reilly found in this case was, and her words were really important. What happened in this case was there were dangerous conditions for these people who were unhoused because of COVID and because of other issues. They went to these motels. These motels got exorbitant amounts of rent. And they received no services, no help, and there was danger to all of these people. None of that's been addressed by Attorney. None of it's been addressed about what happened to these poor people. They were brought into motels that were not designed to be long-term shelters. They were given no services. They were told to cook for themselves. Fires broke out. And what happened was, what happens in any public policy setting with a town, town officials became concerned and then town people became concerned. And I heard Commissioner Douglas say that these were the same old sort of stereotypical complaints. And I understand why you say that. But that's actually what happened. There were concerns about vagrancy, about needles that were found, about people that were not being taken care of or appropriately housed. So what happened? And I'm going to read from Lead Investigator O'Reilly's report because it's very important what she said and how she said it. This is page 8, paragraph 3, the last paragraph. Respondent began its review of motel's license when it learned motel's license. This is not the tent, motel's license. When it learned that there were a high number of emergency calls coming from the motel, 85, extraordinary number. Further investigation showed that there were significant health and safety issues at the motel that created a risk for its residents. The steps that were subsequently taken were an attempt by Scarborough, the town, to make the motel a safer place to live and to reduce the burden on the town's resources. Going down further, it was clear that the motel was not to be meant to be operated as long-term housing for its residents, and the motel was not able to meet its burden of maintaining a clean, safe living environment. While improvements will be made initially, subsequent inspections of the issues recur. As you know, Mr. Douglas, because you read from it, the town at its second meeting, the first meeting, it tabled any action on this. And if you listen to those meetings, people were, especially the town manager, the health and safety people were very concerned about what was happening to these people who were being housed there. And they were very concerned that they didn't have food. They didn't have a safe place to live. And they brought food to them. They gave them as much service as they could, but they required this motel, which is not part of this process, as you pointed out. They required this motel to actually do something. They asked them and told them that and they had to make sure that they had safety on continued on-site security, continued on-site licensed social services coordinators, 8 hours a day. And they said, look, if you don't have these things, that the town fire and police, that the motel owners had to agree the town fire and police could bring the license back up again. This was an extraordinary issue involving COVID, but an extraordinary response by a very small town to a very big problem. Attorney Neal said that the town kicked these people out. They didn't. But the motel decided that it's a motel. And we can't keep running it like this, despite the fact there was money out there. You don't see the motel here fighting to say that these people shouldn't have stayed. The motel made a decision to go back to being a motel, not a homeless shelter that didn't meet the needs of the people who were homeless. So to say that the town of Scarborough and every other town, as was pointed out earlier, is somehow going to be burdened with and kept with a continuing obligation to meet needs that they can't meet in a private motel, and that their actions in enforcing their laws and enforcing their licensing to help these people is discriminatory without any evidence of discrimination on any part is not what this commission was designed to do. In fact, as Commissioner David said, if this is a legislative problem, if this is a government problem, which of course it is, then it needs to be dealt with. It should not be dealt with by this commission telling every town that if you don't have a homeless shelter, you're discriminatory because it is. Thanks.
Questions for Attorney Brogan? Commissioner
Yes,
Sanders.
thank you, Attorney
You're welcome.
Brogan. I'm curious about other motels in Scarborough during this time frame who are also accepting state and federal dollars for housing assistance.
It were, and if you look at the investigative report, there were 5 that were under this process of getting better services. There was one that was actually participating with the town, and the town had a better relationship with that, and they didn't have any problems with that motel. There's a footnote on it. I can't remember. Investigator Riley to tell you which footnote it was, but yes, there were other motels. Some of those motels had the same problems. One motel was very proactive in having social services and making sure that the unhoused people were protected.
And do you know, is that hotel still functioning in that capacity today?
I don't think any of them are still functioning in that capacity as homeless shelters.
And so otherwise, it's your contention that the issue isn't that this motel was functioning as a shelter. It was that the owners of this motel were not functioning as responsible recipients of these state and federal dollars. Is that right?
And they tried, they attempted to, but it really is not, a motel is not designed, it has no kitchens. If the bathroom facilities are limited, these poor people were subjected to some really bad conditions because during COVID and otherwise, I mean, there weren't maids there. There weren't people there taking care of the motel the way a motel was meant to be taken care of. And in fact, there's a note from Investigator O'Reilly. Sometimes there weren't even clean linens available to the residents.
Since my name was the safety concern.
I knew you better than the other people, so.
Nice to see you this
morning.
The safety concerns, you made a representation that it wasn't just sort of people saying stereotypical things. These concerns were actually substantiated.
Correct.
And I'm just wondering, can you say a little bit more about that in terms of what's in the record?
Sure. At the first town meeting, which my memory was, it was May 18th. Residents, police, and fire people all came and said these things that people are talking about exist. There were unfortunate unintended drug deaths. There were needles. There were fires. There were a lot of trash and a lot of unattended trash, which was a real danger to people because that trash was in the hallway. And you'll see in the footnote, it added to the, not a fireman, but the fire chief came in, they were doing fire inspections. And in fact, did one in July, which showed this additional trash in the hallways, which was a huge risk for a fire and a huge risk for. If we were standing here with the tragedy of this motel burning down and all of these unhoused people being killed, or a lot of them being killed, think about what the front page headline would be if the town had done nothing about these expressed safety concerns, which they addressed. Not only did they address, but they didn't say, okay, we're revoking your license, all these people need to leave. They understood that these people needed a place to live and they needed a place to be safe, as reasonably safe as they could be in a motel that was not designed for this. But eventually it passed its course. They could not and did not believe that keeping unhoused people in a hotel not designed for this, where it was unsafe for them, was appropriate.
Right. And so these conditions that were laid out in the September meeting, right?
Right. But actually it started in the July meeting. But as Investigator O'Reilly points out on page 4 of her report at the top, the greatest concern was for the residents themselves.
Right. My question is, so that these concerns, right? The report says that September 21, 2002 meeting, council approved the renewal of motel's license with the following conditions. There are 4 conditions here. My understanding is that the motel was sort of moving to deal with that, but at the same time issuing these notices to evict. If the motel had gone the other way, right? If they had said, we want to keep these people, we're going to continue to operate this way, and we're going to meet all of your conditions. I mean, I guess the town, fire, and police and so on would have the option to sort of move on the license again, right? But otherwise, the license, this program would have continued, right? If these conditions have been satisfied, correct?
Correct. And if the motel owners had decided they wanted to go that direction, it's on the record. I have represented other towns. We read it in the newspaper. These things have gone on much longer with other towns. And it has been, in my experience, I've sat through it. I mean, in 12 hours. The towns and their residents are very concerned about the unhoused, and they're very concerned about not evicting people onto the street. They tried and they worked hard to get to this. The motel owners made a decision that they couldn't do it. And that's certainly their ability, their right to do that. But it wasn't the town saying you need to leave. And in fact, Attorney Neal has not brought you any order from the town saying all these people need to be evicted or closing their hotel, because it doesn't exist.
Commissioner Walker, did you have questions?
Exorbitant rents? I think you used that term.
Yes.
So they were being well paid, the motel was.
Correct.
To house.
Correct. It's not in the record, but my understanding
If
is
it's not in the record, let's
let it go.
leave it. Yes.
I was gonna ask you about the other one.
Well, Investigator Riley can tell you that the motels refused to participate in the investigation. They were not parties. They didn't have to participate. They did not. They did not participate. Wonderful.
Thank you.
You're welcome.
Any other questions for Attorney Brogan? Seeing none, you'll have about a minute and a half.
Thank you.
Attorney Neal, you have 3 minutes.
Thank you. There are just a few things that I'd like to follow up on. Is that Attorney Brogan mentioned that there were other motels, and this was in the record, that there were other motels that also decided to end their program. These other motels were under the same threat of, if you don't get rid of people, we're going to not renew your license. And these other motels in the same time frame then decided, oh, we don't want to fight with this anymore. We want our licenses renewed. We're not gonna go down this road. The motel that my clients were staying at was one of the only ones that stayed open longer to allow people to remain there. And I do want to say that we've been hearing people being called unhoused. Yes, they were unhoused individuals. They were also tenants, and they were residents of the town of Scarborough. So I want to reframe this to say that these residents, we are being told, might become a burden, to use the word that Attorney Brogan used, that the towns would be burdened to provide a place for their residents to go to when their place of residence was no longer able someplace they could stay. And I think that is important. And also the constant use of the phrase, these people. What are we talking about? We're talking about humans. In my case, Ty, Ellis, and Stanford, and Corey, my client, who became no longer able to be residents of the town of Scarborough by the town of Scarborough's actions. Yes, it was the motel they were staying at, but it was the town who said, you need to get these people out of here because we're not going to renew your license if you do not then evict people. I don't have an order. There were conversations between the town, between attorneys and the motel. There were emails all in the record about conversations about what needs to happen. It was an agreement between the motel and the town that for the motel to keep its license conditionally, they needed to evict all of the tenants who were there, who were formerly unhoused individuals, who were now housed, who were residents of Scarborough, who could no longer be residents of Scarborough because they had no shelter that they could go to. They had no place that they could stay within the town because the town told the motel, you need to kick everyone out. And that did disproportionately impact people who were Black and brown, and every single one of those individuals was a recipient of public assistance benefits. And that on its face, I believe, is enough to get us to the even chance standard to say that there is discrimination based on disparate impact and perpetuation of segregation to keep the town of Scarborough at a population of 1% white. Or sorry, 1% Black or brown, all the rest white. And I will answer any questions that you may have.
Commissioner Douglas.
Keep referencing the agreement between the town and the hotel. What I see in the investigative report is, comments and, et cetera, indicating that there was understanding, like the town, understanding is the wrong word. There was an expectation, right, on the part of the town that the motel would cease this program. I mean, was there an explicit agreement?
There was, I don't know that there was an explicit, well, the agreement is contained in the provisions of what they needed to do to be able to keep their business open. So the points that are listed in the report are the agreement they came to of, these are the things you need to do to be able to continue conditionally to have your license to operate as a motel.
Okay. Now, so Attorney Brogan just told us, I asked him, same question, if the motel had complied with these, if they'd gone the other way, right? If they had said, we're going to comply with these provisions, and we want to keep housing these folks. Assuming that they complied to the satisfaction of the town, the program would have continued. What's your take on that?
And that's where I think that information is not in the record, and I can't answer that for you.
Yeah.
I understand the hypothetical entirely, and I certainly have an answer I could give you. I just don't think it's appropriate.
Okay, thank you.
Any further questions for Attorney Neal?
Thank you.
None, thank you. Attorney Brogan, you have a minute and a half.
A couple of things. First of all, I only met Mr. Brown, Mr. Commissioner, and Mr. Ellis during the investigation. Reference to these people, if I said that, I probably didn't. Certainly not meant to be racist or in any way pejorative reference. It's not the first time Attorney Neal has made these claims. She did so during the investigation. It's very, very unfortunate and inappropriate. What we understand from the record and from the evidence is that the town did not do what Attorney Neal said happened, which was they didn't say, if you don't get rid of these people, we'll close you down. It didn't happen. There's no agreement. As Attorney Douglas just said, it didn't exist. The town made sure that these unhoused residents who were in unsafe living conditions lived safer for the time that they were there. And the motel made a decision of this to move on from that. This is not because the town was racist or was unaware of difficulties associated with these people who were living in these conditions. It was the town acting appropriately as a town, as a community to help people. I'll answer any questions.
Questions for Attorney Brogan?
So, Attorney Brogan, you said there's 3 or 4 other motels that were meeting all the conditions for a motel, and we're housing the same population?
No, actually, there were similar difficulties in 3 or 4 other motels. There was one motel that met all the conditions and was keeping the unhoused and had a ongoing proactive relationship with the town and the public safety officials.
And what about the others?
The others were under the same restrictions as this motel.
And closed down the program and evicted the tenants?
Some did, some worked their way through and got to a longer period of time. My understanding is, it's on the record, that none of the motels are no longer are housing unhoused people.
And is that because of the lack of the financial support?
I think it's a combination of a variety of things, but I think the
Yeah,
most.
I'm just gonna step in. Both parties have addressed the motivations of the other motels as to why they discontinued. That information is not in the record. We don't know why those motels stopped. We do know that they're no longer housing individuals who are unhoused. We do know those programs ended, those specific COVID-specific emergency rental assistance programs ended, but we do not know the motivations of the other motels. That's not in the record as to why they discontinued their relationship with program.
Okay.
Thanks,
You're correct.
But your position is that the town administered the requirements evenly across all the 5 motels.
Correct.
Okay. Thank you.
Thank you.
No other questions for Attorney Brogan, I assume? Okay. Since he's long.
I'm happy to go.
He's done taking questions. Seeing none, thanks to the council. We will next hear from Investigator O'Reilly.
Good morning, commissioners. I am going to say a lot on this. I don't normally do this much talking about a case, but I think it's important given these issues, the fact that we don't see these types of cases all that often here at the commission, and the differing positions that you've heard this morning. I first want to say, I think there are 3 really important things in this case that that may not have come across in my report, but one is there's no disagreement. It's definitely true that minorities are disproportionately a disproportionately large number of people who are unhoused, people who are experiencing homelessness in relation to the general population in Maine. That's true. The statistics are there. It's also true that if this were solely a case about increased need by these individuals at this motel, for example, increased need for social services, more police calls, things like that, that alone would not be enough. You do have to provide services to your residents, regardless of those residents' need. If they were legitimately needing additional services because of their status as people who had experienced homelessness in the past and were part of this emergency rental assistance program, that alone would not be enough. I do believe it's footnote 10 that addresses that. I went in my investigation further to determine what really was the issue going on at this particular motel. The third thing is this is a very unusual circumstance, right? The circumstances that brought the individuals to the motel, COVID, the pandemic, unseen before. All of the motels that were part of this program, including the one in this case, was faced with the decision nearing the end of this program as to what to do. So this was not a situation where that really fit into any of the other prior Attorney Neal did mention this morning, and it is true, these were residents. This was the housing provider for the purposes of this program. It was also not an apartment building or any other building that had been constructed to be long-term housing. And that had an effect on the town's actions and my ultimate, determination in this case. So having said those things, I'll address the ordinance issue first. So Attorney Neal brought up this issue of the ordinance that I addressed in the footnote at the beginning of the report. My determination on that matter really was about the individual complainants in this case. It may be true that lack of certain types of housing in certain locations has a disparate impact on individuals who are seeking housing, minority individuals who are seeking housing. In this instance, when I spoke to each of the individuals as part of the conference, they were brought to the town of Scarborough through this program, right? Many motels were part of this program, and the programs that were issuing the funds were trying to find places for people. So they were looking all over, and wherever there was an opening, they were putting people who needed to be housed. None of them wanted to stay. They were all working with, as when they were leaving motel, they were working to get into other locations. So I did not find in this instance that they were seeking, had sought, and were denied housing in the town of Scarborough. So that was really key to my determination that even though the theory of an ordinance possibly being discriminatory in its impact, that was not the case here with these specific complainants. And then I'll get into now I'll talk about the actions of the town. So as I already stated, this issue of the way that the town first learned of the issues at motels, so these calls, this increase in calls, residents being concerned about needles, safety of themselves and others, that was really just the beginning. After that, the town got together with police, with fire, and inspected the property. The town had multiple meetings about this issue. When they first decided to renew the license, they heard from town members, they heard from the residents themselves who lived at motel, come and talk to them about how much they need this housing and please don't kick us out. And they were very attuned to that. They heard those words and they said they did. They talked about it in their meetings. You know, we don't want to put these people on the street. We understand how important this program was to them. What can we do to both keep, deal with these safety issues and also not just immediately evict everyone who's in the motel. It is true that I tried to reach out to motel owners. They did not participate. I spoke briefly with their attorney, who was present at the Issues and Resolutions Conference and did most of the, also presented at some of the town meetings regarding, he was the one who came up with the plan with town. That was what most of the communications were between town with regarding to the plan to transition back to a regular motel. And it really, as you can see in my report, really the issues were the safety concerns that arose out of the fact that a motel is not designed to be a long-term housing facility. In particular, when I spoke with fire chief, he talked about combustible loads, which meant nothing to me. So I asked him to clarify. And really, when you put a fire suppression system in a building, it's rated depending on how much combustible load that building is anticipated to have. How many stoves, how many ovens, how much combustible material is in the building, and the amount of personal effects that were being kept in the building, and the fact that people continually were violating the rules and cooking air fryers and stovetops and things in the building, as well as some of the residents were deactivating the smoke alarm so they could smoke in their rooms, was creating a significant fire safety hazard. In particular, there was a storage room that had fire suppression system in it that was entirely blocked by personal items that were being stacked. So it was issues like that. Oh, I just lost the meeting.
Left out for a minute.
Yeah,
I just want to make sure you can still hear me before.
Yep, we lost like the last 15 seconds. So if you can go back to the combustible load stuff.
Yep, will do.
It's almost like a power.
Speaking of the rapture.
And now I can see the ceiling. I can see the ceiling.
There we go.
Okay. So speaking about combustible load, the amount of material in a building that could catch fire is directly related to how much, what the fire suppression system is in the building. So residential areas that are going to have more personal items have higher suppression systems than places that don't. There was an increased amount of personal items being stored, even in ways that was blocking some of the fire suppression system, some of the egress. So that was really the concern by fire when it came to the safety of the residents. Finally, I think I'm just going to address, I think both parties have made statements about the other party's motivations. I think Attorney Neal has stated things about what town wanted, that they wanted the residents out. And I believe that Attorney Brogan has made statements about town that they were completely without, this was entirely motel's decision and they were completely without desire to fix this problem. I think both are only partially true. I think there definitely were statements in the record, in particular made by residents, but also by a council person, that was about, we don't have to take responsibility for these people. They're endangering our citizens. This is their problem, and we need to just fix this. There were also very compassionate statements made by members of town council that said things like, I'm really concerned that this is an unsafe living environment, but we also need to make sure we don't just put these people on the street. And I think that the mix of that was important to me. I paid attention to it when I did my investigation, but I ultimately found that the town's reasons for, enforcing these rules. And I will say too, I think there's more, the town had more sway over the motel than was presented today. I think they were definitely saying, no, this has to end. we want this to return to a normal business. If it does not, you cannot continue to operate. I think the statements are in there. Again, I don't know what would have happened had Hotel pushed back on that and said, we want to keep doing it. Can we do this instead? Because that's not what happened. They agreed. But there are definite statements made by town that indicate that. For example, there was some communication later on when the program was extended that town thought Motel was going to continue to accept funds and reached out immediately to say, you're not doing this, right? So, and that's a paraphrasing, that's not exactly how they phrased it, but they wanted to ensure that this was not, that the plan that they had agreed upon was going to continue. So I am happy to answer any questions. Again, that's longer than I normally talk about these cases, but this was a complicated one. I do think this involves a lot of really important issues, especially regarding the impact of homelessness on minorities and how a lot of those things have a disparate impact on them. But in this particular case, with these particular complainants, my finding was no reasonable grounds.
Thank you, Jane. Yes, Commissioner Douglas.
Good morning.
Good morning.
Yeah, I'm looking at page 6 of your report. Okay. And there is a statement there that says there's evidence in the record that members of the public and some members of the council felt that the individuals themselves were a quote unquote threat to the community or to the quiet enjoyment of others by the community. And then you go on to say, but the bulk of the concern was for safety. With respect to the threat to the community statement, I'm just wondering, can you say a little bit more about that? In what way did your investigation reveal that these people allegedly posed a threat to the community?
I think it was the general sense of increased crime means decreased safety. Residents were seeing a lot of police vehicles being brought to the property. There was no evidence of actual threat. No one said that. No police officers, no one alleged that there was a threat to anyone outside of the motel itself. There were individuals within the motel. I mean, the types of calls that were being made were involving drugs, involving assaults, involving other safety issues. And drugs, meaning like some people were overdosing, not like drug deals or anything like that. Some warrants for arrests were issued, I think, different things like that. So it was definitely, there was nothing in the record to support actual threat to the community. What the residents were saying were things like, we see needles and there's crime, and that's going to impact our community as a whole.
Thank you.
Any other questions for Investigator O'Reilly? Seeing none, thank you, Jane.
Thank you.
All right. So we have 3 reports with the same proposed finding. I will leave it to you as to whether you want to take them separately or all together.
I suggest we take them all together. And I move to adopt the recommendation of the investigator laid out on page 8 of the matter entitled Ellis versus Scarborough, which I believe is applicable to all 3 cases. Specifically, there are no reasonable grounds to believe the town of Scarborough discriminated against all 3 claimants on the basis of race, color, and or the receipt of public assistance.
Do I have a second?
Second.
Been moved and seconded. Any discussion?
Yeah, I feel like this case, from my perspective, as an African-American litigator, one of the only African-American litigators in the state over the last 20 years, I just want to point out before we vote that I think this case is a lot closer from my perspective than it may be for other folks. I can see how how this all could have unfolded. You know, you have a bunch of residents driving by, seeing people that they don't normally see and saying, don't like it. right? We have a bunch of complaints about crime. These people are now characterized as a threat to the community. And we gotta end this program. I credit the safety concerns. It seems like there is, there is record, evidence in the record about real safety concerns about what's going on there. I credit the comments about the fact that this hotel was not meant to be housing folks for an extended period of time. But I think it's a much closer case than other folks might, and I just wanted to point that out on the record. And I commend Attorney Neal for bringing this case, for these cases. I just don't think this case quite gets there in terms of establishing the discrimination claim, unfortunately.
Commissioner David?
Thank you, Tom. I tend to agree that that it's closer than we might think it would be. But I am looking for, if it was truly discriminatory animus, it seems to me that there would be there wouldn't be the difference between this motel and the other motels if they were trying to drive them all out. And that's why I can't reach finding that the town was discriminating on the basis of race in its actions with this motel.
I'm somewhat concerned with Commissioner David's earlier comments about that it could be a public policy issue. And if it's a public policy issue that puts a burden on a town to have ordinances that allow alternatives, then that needs to go to a different form, not here. So that's why I'm persuaded to support the no reasonable grounds and commend for bringing the case and commend our investigator, Jane O'Reilly. This was fabulous work. Thank you.
Any other discussion? Seeing none, the motion is to find no reasonable grounds. If you vote yes, if you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
So the finding in all three reports is no reasonable grounds. The commission will send a letter to the parties in council, reflecting the results of the hearing. Attorney Neal, if you're available to stay on, I believe we have Ms. Wallace for the next case.
Except that my clients don't think it's going to start until 12:30, and that's the reason why I'm here in person.
Okay. Are they coming in person?
They are coming in person.
Well, that throws
Sorry,
a wrench in my
yeah.
plans. We do, I think, have I have asked the parties I've asked Ms. Earl in Earl v. Hassett and Maloney to join us at 11:45, which she's agreed to do. So we could take a break. Your food should be here shortly.
It's here. It's here.
The food is here. It's here.
That was
Take a
fine,
break,
but I guess-
have your lunch. We could pick back up at 11:45.
Brixton's good.
All right.
So 11:45. Yep.
Thank you.
So do we have a case we can start or what?
Okay, Ed, we can hear, Earl versus Hassett and Maloney. Mary Beth was on.
Okay, where'd Mary Beth go?
Hang on just 1 second. I want to see if I can, Mary Beth was on. She seems to have left. I'm gonna see if I can find her.
So that's Earl versus Hassett, right? Or are we waiting to see if you can find her, or
Yeah,
there's somebody named Rose displaying, as you see, but
Rose is the complainant. That number you've pinned, Chelsea, is for the Wallace case. Newbert, do you have a phone number for Mary Beth or Robert?
I can check. No, I don't see a phone number for her or Mr. Maloney.
We've got one, Kit is calling, he's like.
Okay.
What? Great, signing on just now.
Yes, great.
Good.
Fine now.
Just one will do. Thank you. That was weird.
Yeah. Okay, here's my suggestion. While I'm waiting to hear back from Mary Beth in the Earl v. Hassett and Maloney, why don't we move to Lisa Young versus the Pines, because I believe we have everybody here for that case. Aubrey, is Elizabeth Harold your client?
Yes.
Okay. That all right with everyone? And does that work for you?
Sure.
Okay.
So we will hear H 230461 Young versus Pine Senior Community. The recommendation is for a finding of reasonable grounds, and therefore we will hear from respondent.
So Attorney Russell, you have 10 minutes. Would you like to reserve any of your time?
Yes, please. I'd like to reserve at least 3 minutes, but I don't think that I'll take nearly that time.
Okay, great. Whenever you're ready, go ahead.
Thank you. So I represent the respondents in this matter, and it's the respondent's position that they did not discriminate against the complainant. From our viewpoint, there are two key interactions that are key to this investigation. The first occurred in December of 2022. At that time, the respondent's pre-application stated that the complainant had one dog. The person working at the time is no longer with the respondent, so they had to work off notes that were in the file for the respondent and the commission in order to reply to the commission. Those notes state that Ms. Young told the admission person that she had two dogs when they discussed her application, and she was then told by the property manager at the time that they had a one pet policy, at which time she added that she also had two cats that were assisted. The term was not addressed by either party, nor was there any other indication that the complainant had assistance animals, but it was specifically with regards to the cats, keeping in mind that she had two dogs, which would be above what was permitted by the pet policy. The respondent at that time did not interpret that as statement to mean that she had assistance cats, nor did it occur to them that she had 4 assistance animals. At no time in December of 2022 did respondent indicate that it did not matter if the animal was an assistance animal, as stated in the report. Respondent did not state that it would not matter if complainant had a doctor's note, or that, and respondent did not state that they did not accept the unit, that she could not accept the unit due to her assistance animals. Again, from respondent's point of view, they couldn't have said that because they were not considering these assistance animals at that time. At that time, respondent did not understand these were assistance animals, so respondent could not have made those statements. Respondent told her she could not accept the unit because she had more pets than were allowed. 2 days after that discussion, complainant did call back and she did ask for the unit, and respondent would have provided her the opportunity to go through that process, but they had already rented the unit. So the unit was no longer available to even discuss. Then fast forward to November of 2023, the respondent contacted the complainant because there was an upcoming unit at their property that she was eligible for, and she was up on the list at Pinewood Manor. At that time, respondent inquired if she still had multiple animals, and she said that she had 2 animals. Respondent and complainant discussed that complainant was not interested in the unit offered at Pinewood Manor because she didn't want to live at that property, and she requested to be removed from the wait list at that time. As a result, respondent removed complainant from that wait list, but left her on the wait list for the Pines at Ocean Park. At no point was there discussion about her being denied for her animals, or any further discussion about that, or what the status was of her animals, because she did not want to live at that property. Yes, complainant provided the investigator letters from her healthcare professionals, dated in August of 2023 and November of 2023 that do support that she has assistance animals. However, I think it's very important to note that my client did not receive any of these letters and they at any point during the process until after the hearing on February 8th of 2024. So in conclusion, in December of 2022, complainant was told that she could not accept the apartment because she had too many pets, too many animals. She had the 2 dogs and the 2 cats. And at that time, even if the commissioners believed that my client was aware that the 2 cats were assistance animals, the extra dog made her not eligible. But my client states that they were unaware of any of them being assistance animals. She called back 2 days, the complainant called back 2 days later to accept the unit, but at that time, there couldn't be any further discussion because the unit was no longer available. In November of 2023, the respondent never gathered information regarding the animals because the complainant did not want to live at the property she was being offered. She asked to be removed from the wait list for that property, and she was. She remained on the wait list for the other property and continues to be on that wait list. Respondents did not have the necessary information to discriminate against her based on her assistance animals because at no point during the time they were making their decisions did they have the information that she had 4 assistance animals in December of 2022 or 2 assistance animals in November of 2023. Thus, we ask that the commissioners find that they did not discriminate against complainant.
You'll have about 5 minutes when we come back to you. Commissioner, questions for Attorney Russell? Commissioner Sanders.
Great, thank you. Hi, Attorney Russell. Thank you for coming. One quick question about your narrative that you submitted in response to the investigator's report. About halfway down the first paragraph, there's a sentence that starts with the notes in the file state that. So I'll just go ahead and quote it. The notes in the file state that Ms. Young told the admission person that she had 2 dogs, and she was then told the property had a 1 pet policy, at which time she added that she had 2 cats and then stated they were assisted. And so I'm curious about, isn't that expression to folks who are trained, right, and in the business of letting out properties to rent? When a potential tenant says their animal is assisted or they may need some assistance, isn't that enough to trigger some follow-up questions from the entity to assess what is the status of those animals, right? Are they pets or are they assistance animals?
So I think that is a very legitimate question. And unfortunately, we don't have the information as to why further questions weren't asked. What I do think is important to note is that those were specifically with regards to the cats. And that's why in my conclusion, I stated that either way, that she had 2 dogs and she had not made any indication that either of the dogs were assistance animals, that it was, the statement was specifically with regards to the cats.
Commissioner David.
Attorney Russell, is it your position that that the 1 pet policy would overrule a submission that the 2 dogs were assistance animals? In other words, are you saying you were saying that the landlord could say, no, you can only have 1 dog because it's our policy as opposed to 2 assistance dogs?
No, I think that if the respondent had information to believe that all 4 animals were assistance animals, they would have had to have gone through the process of either granting the reasonable accommodation or going through the process of engaging in the interactive process to make that determination at that time. They couldn't have just relied upon their policy, but rather my clients, you know, from their position, they did not understand that the word assisted meant that for the cats. But even if you were to take the cats out of the equation, that they didn't realize at any time that the dogs were assistance animals in December of 2022.
Yeah, but you would agree that that your clients relied on their policy that you can only have one animal. That's it. We're moving on to the next applicant. And they did within 24 hours, right?
Yes, that is correct, that they relied upon that, but based on the fact that she didn't indicate that she had 4 assistance animals.
Thank you.
Other questions for Attorney Russell?
Just,
Yes.
sorry, one last question. Attorney Russell, I'm curious about sort of your client leading, right, with the response to communicate to the complainant when she mentioned, right, that she had animals, they led immediately with, there's a one pet policy. Isn't that misleading for your clients to do that, right? Not drawing the distinction for potential tenants, right? There's a distinction between a pet and an assistance animal, and really working with that potential tenant to do the analysis and put that animal in the correct, put it in the correct box so the analysis can be appropriate. I'm just curious about, that seemingly, right, your client leads with one pet policy, and seemingly that's the end of the discussion, at least at that time.
Sure. So I think that I don't think that it's misleading. I think that it is very typical for clients to make people aware of their policies and what they're permitted to have. And then at any point, a tenant can request if they want an accommodation to those policies, just with any policy that a landlord has. I believe that there's only certain groups of landlords that are required to take the extra steps to ensure that people are aware that they have the rights, and to put into writing that they have the rights to request an accommodation to each and every policy. Those include, housing authorities and certain types of funded, but I don't think that that is a necessity for all landlords to take that extra step to say, well, if you have 4 animals, how many of them are assistants versus how many of those are pets?
Although, would you agree with me that that would be good practice for a landlord to employ in their business, correct?
I think it would be, best practice, yes, but I don't think it's required by the law.
May I say something?
Who is that?
I'm the respondent.
Oh,
With the
sorry,
Carol
Ms.
from the
Carroll, we
Pines.
don't have you pinned. Just
Okay.
1 minute, okay? Okay. Sure.
Are you sure that you want to speak, Liz?
Seems like perhaps your attorney is suggesting that you don't. All right. Up to you. We don't give you legal advice here. All right. Any further questions for Attorney Russell? Seeing none, you'll have about 5 minutes. Ms. Young, you have 10 minutes. Would you like to save any of that time? Oh, you're muted.
Yes, could I save 3 minutes?
Sure.
Okay, I wrote something, so I'm just gonna read it. Monday, December 5th, 10:30 a.m. I toured an apartment with Ida, the admissions representative at the Pines
Ms. Young.
community. Yes,
Please don't use the names of third parties.
third parties.
So whoever was it you toured the apartment with, please don't
Okay.
use that.
Okay, admissions representative at the Pine Senior Communities in their Pine section. I was told I was called because they had to fill a spot with this under 62 person disabled. I was told I would have unit 16. The unit was still occupied, so I was shown an empty unit. I was shown where unit 16 was and the parking spot for it. We also toured a workout area, laundry room, and community gathering space. After that, we went to the office and was given a list of additional paperwork that was needed to move in. This included a full application, tax returns, birth certificate, etc. The conversation went to the topic of animals. I mentioned I had 4 animals, including a foster dog, as I volunteer for a small dog rescue, a cat, and 2 Shih Tzus. The admissions representative stated that the community only accepts one pet, to which I replied, even with a doctor's note. I stated the foster dog could go to another foster within the rescue, that my cat was 17 and at the last stages of her life, and that she could stay with my roommate. I stated I did not think it was an unreasonable accommodation to have 2 dogs under 10 pounds each. Her reply was, we only accept one pet, that a doctor's note that would not matter, and that our director would never allow it. She mentioned that we had a man move in with 2 birds. Our director made him get rid of 1 bird. Both birds ended up dying. She stated she would refuse the unit on my behalf and told me I would remain on the wait list, that I was number 69 as of that date, and that she hoped she could find someone under 62 to fill that unit and rush me out of the office. That afternoon, I contacted my counselor of over 17 years. I also contacted my counselor at my day program and my other counselor with a community counseling program, as well as my prescriber. My prescriber stated that she agreed my dogs should not be separated from me, neither should they be separated from each other, and that she would write me an ESA letter. After thinking about it some more, I realized that Unit 16 was on a corner, that the parking space for it was very close, and the parking space had an aisle on one side. I would not be afraid to get out of my vehicle at night to go in. I had also driven by Unit 16 the night before, on December 4th, to see the lighting outside, and it was good. My primary counselor called me back on Tuesday morning as I was still in Maine, December 6th, to see how I was doing. He mentioned that I should put all the paperwork they requested together, add my letter from the doctor, and mail it all in. It was my understanding from the law that they would have 10 days to agree or disagree. He also suggested that I call them and let them know that I would be accepting the unit and send in the information. My other 2 counselors also agreed. I called Wednesday morning, December 17th, from the parking lot of a bagel cafe in Scarborough, and got no answer. I left a voicemail and she called me back immediately. I told her I wanted to accept the unit. She stated the unit was no longer available, that I had refused the unit, to which I replied I did not refuse the unit. She said we moved on. I would still be on the wait list. I mentioned that felt I needed to advocate for myself and that I would like to put in a complaint with HUD, to which she replied, go ahead and do that, and hung up. Forward a year later to Tuesday, November 21st. I received a call that a unit was available in their Manor building. I mentioned that I really wanted to live in the Pines section. She advised that I could take my name off the wait list for the Manor, and then I would still be on the list for the Pines. She asked me why I didn't accept the unit the year before, and I told her that I had had a knockdown, drag them out kind of thing with the admissions representative. She said, yes, we only accept 1 animal. I again said, even with a doctor's note, she said, yes, it's been determined with HUD in the state of Maine that we only accept 1 animal. This is when I investigated where I might be able to make a complaint, and I was referred to the Maine Human Rights Commission by the woman I used to rent from in Old Orchard Beach. My question is, why the same thing twice when I mentioned doctor's note and accommodation? I've struggled since then, and almost ended up in the hospital last year in the summertime from the stress. And I just don't understand. So I asked the Maine Human Rights Commission to uphold the investigator's recommendation and find that there are reasonable grounds for discrimination.
You'll have also about 5 minutes. Any commissioner questions for Ms. Young? Seeing none, we'll turn to Attorney Russell. Attorney Russell, you have 5 minutes. Whenever you're ready.
Thank you. Just quickly, my client responds that in December of 2022, again, we don't have the person that was there, so we don't have her to state what actually occurred, but from the notes, there's nothing. The notes were pretty detailed, and it does not indicate any discussion about, you know, if I have a doctor's note or anything. We've provided what we believe was discussed. And then in November of 2023, they denied that there was any discussion about a doctor's note or about the what ifs, and that there really wasn't any discussion about the animals beyond how many animals she had, because she stated that she did not want to live at that building.
Commissioner, questions for Attorney Russell? Seeing none, Ms. Young, we'll come back to you one more time. You have 5 minutes if there's anything else you'd like to add.
I would just like to state that, yes, there was that little bit of a conversation in November of 2023. When again, even with the doctor's note, no, we only accept one animal. It's been decided with the state of Maine and HUD that we only accept one animal. That's all.
Commissioner, questions for Ms. Young? Seeing none, we'll move on to Investigator Morse.
Hi there, this is Angela Morse. I was the investigator assigned to this case. I just want to highlight 3 things. In the respondent's answer, these are from the notes taken by the admission counselor, December 5th. It's discussing Ms. Young looking at the vacant unit. Ms. Young mentioned that she had 4 older cats and dogs that were assisted. There was never discussion about cats being assistance animals, so I'm not sure where that came from. Also in the respondent's answer, there is the pet policy. Just scrolling to that. A resident may have no more than 1 common household pet at a time. Scrolling down, it then discusses service therapy animals. And under that section, for the purpose of this guideline, the fish or animals that can reasonably kept in an aquarium or a cage constitute, quote, 1 service therapy animal. And throughout this section, it references an animal. So it's very clear that it was envisioned that there would only be 1 therapy animal allowed. And lastly, this is from my discussion with the executive director of the Pine Senior Communities. Her understanding is, and these are my notes, her understanding is that there was more than 1 animal. There is a 1 pet policy, whether that is a pet or a service animal. Ms. Young indicated that there are several animals. It has been the policy that tenants can only have 1 service animal. The apartments are not huge. It doesn't depend on the size of the pet. They have never had any guidance. They have seemed to have met the need. They've never had requests for more than 1 service animal. Never had this issue. People who have had multiple animals have been turned down. Policy is that more than 1 is not allowed. That is the end of discussion. And that's what I wanted to highlight, and I'm certainly willing to take some questions.
Any questions for Investigator Morse? Seeing none, thank you, Angela. We've heard from the parties and the investigator. At this time, we'll be looking for a motion. There is 1 proposed finding. Commissioner David, was that a hand or were you just gesturing?
Yeah, great. So I move to accept the investigator's recommendation that there are reasonable grounds to believe that Pine Senior Communities discriminated against Lisa Young on the basis of disability and housing.
Second.
It's been moved and seconded. Any discussion? Seeing none, the motion is to find reasonable grounds. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
So the finding is reasonable grounds, and the commission will send a letter to the parties and council communicating the results of the hearing.
Who do we have available, Kit?
At this point, we don't have anybody. I think Attorney Neal expects their clients at least 12:30. I have reached out to Mary Beth Hassett and Robert Maloney several times, and I just make sure that I haven't heard anything from them. I don't know that they were planning to present. I had informed them that I would be recommending that you hear their case, but that they didn't have to present if they didn't want to, and recommended that they listen to the beginning of the meeting and then make a decision as to whether or not they would present. So I know that Mary Beth was here in the morning. She doesn't seem to be here now. I think we could do one.
And they don't have counsel, right?
They do have counsel. I have been CCing him on all of the emails. I have never had a response from him, so it's unclear to me whether he currently represents them or not.
Okay, do you know what that phone number is on the screen?
Yes, that is Sandra Wallace, who's here for the Sterling case.
Right.
So
Well,
we could, go ahead, Ed.
no, what do you suggest? I mean, it sounds like Hassett and Maloney are going to default if they were here and now they're gone. But maybe they're waiting till 12:30. I don't know. You say they were here?
Mary Beth was on the Zoom earlier this morning.
Okay.
So we could go into executive session now.
Yeah, I think if we could do that.
Okay.
Yeah.
All right. Let's do that. Ed, I'm gonna put you in a breakout room.
And I'll just accept that
Oh, we need a
invitation.
motion. Yep, we sure do. Motion would be handy.
All right, I will move that. Yeah, I got it right in front of me. Well, I thought I did. Pursuant to MRSA 4056E, a move to go into an executive session to consult with our attorney pending litigation and our legal rights and duties as a commission.
Been moved and seconded. Any discussion? If you're in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders? Yes. Great. Okay, now I'm going to put you in a breakout room, Ed.
Thank you. Okay, so I have a motion, two of them actually.
Whenever you're ready, Ed.
Yes, I move that we approve settlement in Buckley versus Graves, H20-0423, as recommended by council.
Second.
It's been moved and seconded. Any discussion? Seeing none, if you're in agreement with the motion, you'll vote yes. Commissioner David?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
And I move that we not litigate the list of cases in council's memo of February 24th that we just reviewed. There are 3, 6, 7, 8 cases.
Have a second?
Second.
Douglas, all right. It's been moved and seconded. Any discussion? Commissioner David?
No.
Oh, you're ready to vote. Okay, no discussion. If you vote yes, you're in agreement. Commissioner David?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
Okay, thank you.
So who's available?
All right, so now it is officially after 12:30. I do not see Mary Beth or Robert in the Hassett and Maloney case. So
Alice's clients.
Alice's clients are here. So I think
Well, let's call
Earl versus Hassett. Maloney. Okay, go ahead.
No, we're going to call, Earl versus Hassett, right? So the next case will be H230404 A and B, Rose Earl versus Mary Beth Hassett and Robert Maloney. And that is don't tell me, it's a reasonable grounds case, and therefore we would hear from respondent. Is respondent ready to present?
I do not see them on the Zoom. I have emailed them both along with their attorney. I have no response. I have texted Mary Beth, who's the only person for whom I have phone number, and called and also received no response. So I am assuming at this point that they are not present.
That being the case, I don't think we need to hear from our investigator. I mean, I think we're ready to make a motion that we find that there are reasonable grounds to find it was discrimination and conciliation should be attempted.
Do I have a second?
Second.
All right, any discussion? None. It has been moved and seconded as a motion to find reasonable grounds. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
Okay, so the finding is reasonable grounds, and the commission will send a letter to the parties reflecting that. Ms. Earl, I appreciate you coming on early and apologize for the fact that you then sat here for 45 minutes, but we will send you a letter in the mail in the next day or so. Appreciate your participation.
Thank you. Have a good afternoon.
Thanks. Okay.
Great job, Newper.
So we're ready to hear H23-0352, Nichols and Alley versus Wallace. And that is a recommendation for no reasonable grounds. And therefore we would hear from complainant.
Attorney Neal, would you like to reserve any of your time?
3, please.
Whenever you're ready.
Okay. So the facts that I want to talk about, or say, good afternoon, commissioners. I know I was here earlier, but my clients don't know that. Good afternoon, commissioners. I'm Alice Neal. I represent both Sterling Nichols and Danielle Alley, who are here in the back of the room. And they brought this case on behalf of their minor child. And there are some facts that I want to talk about that I think are crucial to both of the reasons why I believe that a reasonable grounds recommendation is appropriate in this case and should be what you find. And those facts go to the fact that there's a legal process for landlords to evict their tenants. And that legal process starts whenever you take your tenants to court. It doesn't mean you just tell your tenants, I want you gone, potentially. And that's the crux of what it sounds like the timing is here in terms of the case. So I think the things that are really important to remember in this case is what happened on August 5th and then on August 6th of 2022. And so on August 6th or August 5th of 2022, minor child was engaged in a conversation with the respondents in this case and also a neighbor. And I am going to, I think it's in this case is based on sexual orientation and gender identity. And I believe that is crucial to understand the framework of this is that nothing happened to my clients to try and evict them through the court process or then threaten their property or try to get them to leave until after their minor child had a conversation with the respondents nearby and present hearing about his sexual orientation and gender identity. And so he was there, and it was after that conversation that then a month later, the respondents decided, we're going to actually avail ourselves of the court process. We're going to take you to court. But the next day, immediately after this happened, there was an altercation in between Sterling and then also Gilbert Wallace. And this was recorded and provided to lead investigator O'Reilly. And during that altercation, Gilbert said, essentially, get the fuck off my property. And I am going to swear because I think it's important to use the words that people use. He was told to pack your shit. And it was immediately after this incident happened on August 5th. And I think that it's the best testimony about what happened on August 5th is what minor child's statement was about 10 days after that incident happened. And I'm going to read that even though I've sent it in. And minor child said, around 2 o'clock, I decided to head to Gilbert's house to see if the kids were there to play with them. When I got up to his house, Sammy, Gilbert, and Sandra Wallace and blank were all there talking. I'm going to insert neighbor there. That's who that was. And neighbor were all there talking. They saw me and started talking to me. I told them I had hurt my knee yesterday. Then the conversation drifted to about me being interested in transitioning. This is when neighbor started getting aggressive, yelling, slamming on the table, saying comments like, if you were any older, I would have thrown you up against the truck behind you. If you were my kid, I would have beaten you. If you don't change for the better, I will beat you straight. At this time, Sammy was in agreement with neighbor and said, you haven't even gotten a piece of pussy yet, so why do you think you want to be female or suck a cock? Then neighbor asked me if I would rather have a guy or a girl. I responded, both. He slammed his hands down on the table and then walked away, mumbling something under his breath. Sammy said, I would straighten up if I were you, little boy. You don't want to mess with neighbor. If you do, you will have me, Gilbert, and Sandra to deal with, and you couldn't handle that. 3 to 5 minutes later, neighbor returned to the table a little calmer. I tried to act normal and move on. I complimented neighbor, and I can't read the word that is there, saying how they look really, boots, how they look really high quality and wish I had a pair like that. Sammy said, you never compliment a guy unless you're gay. I said, okay. Then as they were leaving, neighbor grabbed my neck, shoulder, and squeezed to the point it hurt and said, did I scare you straight yet? I had to say yes, because in that moment, I felt my life was being threatened, or at least I would be beaten if I said no. Then walked away, and I went home and told my parents that night. The next day, his parents had the cops come out. They were there. Sandra and Gilbert saw the cops there and came down. This led to a confrontation that was recorded that the investigators listened to. And that is where Gilbert said that minor child wanted to be a girl. They're talking about the conversation, and Sterling said, if he did, what is it to anybody else? And Gilbert said, pack your shit and get the fuck out of here. Sterling then tells them that's harassment. And then Sandra says, you want a harassment? I'll go to that, go start the ad excavator and I'll harass you, motherfucker. I'll come out here and kick everything up. And Gilbert tells Sterling, you have no right to be on my fucking property, and assaults him by punching him. And this led to some criminal charges. That's in the record. And it was only after this chain of events where the minor child had a conversation where the respondents were present, which they deny, or I should say that Ms. Wallace denies, was part of the Issues and Resolutions Conference, that then started the chain of events of them actually going to court to evict Sterling and Danielle, making housing unavailable and retaliating against them by just threatening to destroy their property and other things while they were still tenants on the property. And in the record, you read in the report that there were concerns about non-payment, that they said that they weren't going to pay rent whenever they were not utility pickups or other things that were there. However, they would occasionally get cut off. And that's also referenced in that conversation that's recorded, where you can hear that there is a recording where they're trying to say, but we've paid you some rent. And Sandra saying, I don't have a bank account essentially that'll show that. That's not a direct paraphrase. It is quoted in the submission of disagreement. But they're saying essentially, oh, well, you want to say that you paid us. We won't say it exists. And I know there's been a question about a credibility determination in this case. I would argue that the Wallaces equally have credibility issues if that is something that is being considered here. And that by them saying, well, we'll say that you haven't paid us. And I think that based on the commission's even chance standard and the timeline, specifically that none of this started in taking the Nichols and Alley to court to try to evict them until after this incident happened with minor child and then the assault the next day. And I will take my warning and take any questions if you have any.
Any commissioner questions for Attorney Neal? Commissioner Douglas.
So if I'm reading the report right, there were sort of more informal efforts or statements to the effect of we're going to evict you prior to this incident that you just described. Can you just talk about that a little bit?
What I know and what's in the record is that they'd been behind and there have been conversations where they'd be like, okay, there might have been one or two conversations from what I know that they had said, you know, we want you gone. But then they would come to an agreement and they would still stay on. And so there had been that kind of back and forth a little bit here and there. It wasn't until after August 5th and 6th that they then a month later or less took them to court.
Okay, thank you.
Commissioner David.
In that same vein as Tom was just asking you, Attorney Neal, don't you have to show that that the eviction is a pretext, that the claim that they were evicting him is a pretext for covering discrimination?
I do think it is. I do think that they were being discriminated against because of minor child sexual orientation and gender identity. I think that I do think that the eviction was based on his sexual orientation and gender identity. I do not believe.
And that's in the face of them not paying rent starting in March. Is that your position?
They stopped paying rent in the spring, yes. But then they paid some after that, here and there.
Okay, thank you.
Any other questions for Attorney Neal? Seeing none, you'll have 3 minutes. Thank you. Ms. Wallace, you can go ahead and unmute yourself. If you push *6 on your phone, I believe that should do it. Great. All right. You have 10 minutes. Would you like to reserve any of your time?
No.
Okay. Go ahead whenever you're ready.
I don't know what I'm supposed to do. I just thought this was another meeting and contradict things, I guess. I did try to have them leave in March. I posted notes on the door, which they admitted that they got, and it was in March. So it wasn't after all this other stuff that he's saying's happened. So I pretty much don't have anything else to say that other than what I've already said.
Again, a record for the shortest presentation today at this meeting. You'll have about 9.5 minutes left. Any commissioner questions for Ms. Wallace? Seeing none, Ms. Wallace, I'm going to mute you while Attorney Neal does the last of their presentation, and then we'll ask you to unmute again after that, okay?
Okay.
All right, so Attorney Neal, you have 3 minutes.
Don't think I will use all of that. Just want to quickly clarify that Ms. Wallace did just say that she had given them notes or tried to give my clients notes. My clients have maintained this entire time that they didn't receive those. And when asked to produce them as part of the court process, the Wallaces were unable to produce any evidence they've actually given any prior notices to Sterling or Danielle, and that's why they had to dismiss an eviction process and then start again.
Any questions for Attorney Neal? Commissioner David and Commissioner Douglas.
Attorney Neal, I'm confused with the naming that goes on here, both with surnames and last names. Which one of the complainants, Sterling Nichols and Daniel Alley, do you allege was discriminated against?
So I can hopefully try to clarify that for you. It's an association with claim because they are the parents of the minor child. And so they are both discriminated against, and they brought this claim individually and on behalf of minor child. And so the claim is that both parents were discriminated against and minor child was discriminated against.
By whom? By Sandra Gilbert?
By Sandra Gilbert and Sammy.
And all 3 are in the conversation in August?
All 3 were present for the conversation on August 5th, yes.
Thank you.
Yeah, I'm just thinking through I think the timeline here is the biggest problem in the case, right? I mean, so if I'm having all this correctly from the presentations, your clients stopped paying rent in March, right? And the incident that you described, the confrontation with the neighbor, the police coming the next day, that happened in August.
Correct.
So your clients have not been paying rent in March, April, May, June, July, August. And then the eviction action is in September, correct?
That is correct. Although my clients do maintain that they paid some rent during that time, not full rent during that time. And if they would come to agreements with Sandra and Gilbert to be able to stay, they would have the conversation, they'd pay something, then they'd be able to stay.
There's no lease here or anything like that, right?
It's a verbal lease.
Verbal agreement. Okay. All right, thank you.
Any other questions for Attorney Neal? Seeing none. Ms. Wallace, if you have anything else you'd like to add, you have 9.5 minutes. Again, it's *6 if you'd like to unmute yourself.
Yes, I would also like to add that when they first got out on my property, it was supposed to only be for a couple of weeks because their motorhome caught fire on a road right beside my road. And they didn't know anybody, so they asked if they could park their motorhome on my property in long enough to get it fixed, and then they just would not go. So I just needed to add that too. And that was like November, and it snowed and everything, and I lost my son in January, and everything was all screwed up, and I guess that's all I needed to add.
Any commissioner questions for Ms. Wallace? Seeing none, we're going to mute you again and we'll move on to the Investigator O'Reilly.
Good afternoon, commissioners. My name is Jane O'Reilly. I was the investigator on this case. I don't have much to add. I think it's clear in my report that I felt there was enough information in the record prior to the incident on August 5th and 6th to support that the eviction was based on rent and not on this incident with minor child. I will say that the severity of the harassment, which I know is disagreed with by Attorney Neal, my description of the incident in the report, Attorney Neal has stated in their submission disagreement, was not accurate. even if, and the recording that was provided, I will say it was difficult to hear everything, and I heard differently, but I cannot hear clearly enough to be sure that Attorney Neal's recitation of what was said is incorrect. But regardless of the severity of the harassment, that is not extra support for a causal link, if that makes any sense. So the harassment could have been even more severe than either one of us are recording, but that would not increase the support for a causal connection between the harassing incident and the reason for eviction. So the recording is a several minutes long, highly contentious argument that happens with yelling on both sides. It's clear that they disagree about what harassment occurred, and it was my my determination after listening to that recording multiple times and hearing the parties discuss the ongoing issues at the IRC that the eviction was based on failure to pay rent and not the minor child sexual orientation. I can also add, I can speak more to the, sorry, Commissioner David, I can speak more to the issue of the association claims if you'd like me to describe that a little bit more.
Thanks, Jane. Any commissioner questions for the investigator? Commissioner Sanders and then Commissioner David.
Thank you, Investigator O'Reilly. I'm curious about what you make of Attorney Neal's argument, right? That even though since March of that year, complainants had not paid rent, right? It was only just sort of, very closely within hours of that very troubling exchange that took place, that the respondent then moved to actually initiate an eviction process. Couldn't you reasonably conclude, right, based upon the facts, that the child's gender expression, gender identity, and sexual orientation was at least one of the reasons why respondents wanted complainants on their land?
So sort of the straw that broke the camel's back kind of situation. Up until then, there were issues, but they weren't the major problem. And then this happens, and that just causes. So couple of reasons. One is, so here's the timeline of, and the sort of people involved in what happened. So first of all, there's sort of a break in what respondents may or may not have been aware of in terms of minor child sexual orientation and gender identity. They were aware of something. It can be heard on the recording. I believe it's Gilbert making a comment, he said he wants to be a girl. That is in the context of them discussing. So let me back up. Minor child is in a conversation with Samuel Wallace, who's one of the named respondents, and neighbor, who does not reside on the property, but is an adult male who owns a neighboring property. This interaction occurs. There's disputes about who was there, who witnessed it. Complainants say that Sandra and Gilbert Wallace will witness to this conversation. Sandra denies she ever witnessed anything involving this type of interaction. But regardless, minor child reports that to his parents that evening. The following day, they call the police. So the recording starts with minor child having a conversation with the police officer with his parents present. So Sterling is making a recording of the child's report to the police. Sterling has the conversation with the police officer. He asks the police officer, should I go and talk? And I'm going to paraphrase a lot of this. None of this is word for word from the recording. He says, should I go up and talk to them? The police officer advised, don't talk to them. Don't go up and have any conversations with them. He starts to walk away. Gilbert and his son Samuel have seen the police officers there. They approach Sterling and Danielle and say, what are the police doing here? What's going on? Sterling says, well, names the neighbor. Neighbor harassed my son. Sandra joins at some point. There's a discussion. No, that didn't happen. No, they were just talking at the picnic table. No, he grabbed him. No, I think, all he ever said was maybe he wanted to be a girl. Gilbert says, what's that to you? It escalates into Gilbert saying, you haven't paid rent for 6 months. We've been trying to evict you. Gilbert says, that doesn't count. Gilbert assaults Sterling physically. It gets pretty heated very quickly. There's a lot of yelling going on. Sterling and Danielle do eventually walk away, call the police again. And while they're walking away and Danielle is making that phone call, you can also hear Sterling yell to neighbor that he uses explicatives, harassed my kid, to which neighbor laughs, says, no, I didn't. And then the recording ends when the police officer returns, the same police officer that was there previously. Again, and this will, unfortunately, I can't play the recording for you. My assessment of that conversation is that the escalation happened, when the issue of rent came up, and B, when it's clear there's hostility even before the conversation starts, when Sterling Sterling accuses Sandra and Gilbert of harassment. He says, you harassed my kid, you're harassing my kid. I also found it very troubling, and I continue to find it troubling. I understand that it's not technically a misrepresentation to say that the eviction process started later, but to say that they weren't aware is not only misleading, but contradicted by complainants' own statements when I talked to them at the IRC. They did not fall behind on their rent. They intentionally withheld it because they believed they were not being provided the services they should be provided. They reported to me that they were aware in at least early summer, if not before that even if they hadn't seen the notes, that the notes were being attempted to be placed on them. I didn't find the fact that the officialness of the eviction happened later to be a sort of triggered by the sexual orientation incident as much as it was a continuing escalation of this ongoing conflict. It is very confusing. It all happens within the same time, but I didn't feel, especially given that the crux of, at least of the larger context of the whole argument, that it was the orientation. It was this issue of the kid's sexual orientation that was the issue that was bothering respondent. They didn't seem to care about that as much as they cared about the accusation of harassment, and they cared about the fact that this guy was still causing trouble for them by, not paying rent and not leaving the property. So take that as you will, but that was the full sort of, it was a complicated case. A lot of facts, a lot of details in this very specific, very 2-day period time frame. And it was troubling, but again, I found that even the increase in severity of the incident didn't increase the connection between the incident itself and the eviction, especially given that neither Sandra nor Gilbert were actually accused of making harassing or discriminatory statements toward minor child. The main perpetrator was neighbor, who was not named and was not involved in the tenancy of the complainants at all.
Thank you. That's very helpful. I appreciate it.
Commissioner David?
Jane, do you find Sandra credible when she talks about how this started, that it was a neighbor that wanted to come and park their RV because they'd been burned out? They don't rent land out to IV people.
So the tenancy, yes, I find her credible. I think there are some details that are probably missing, or there was some maybe miscommunications too between them over the course of this tenancy, but I do believe that it started out as a temporary tenancy. So complainants became aware of this property because they were assisting their cousin to move on to the property, who does actually rent from Sandra. I don't know if the cousin still does, but at the time the cousin rented from Sandra and Gilbert. So they moved on to the property, and then it just, Sandra was consistent in her, and complainants reported that this was an ongoing conversation. They had stopped paying their rent. They were arguing about the tenancy. Sandra's recollection was that they basically kept coming up with excuses. I heard from Attorney Neal that there were sort of agreements. There were verbal agreements. There was maybe one verbal agreement, and then there were just sort of, I want you to leave. No, please don't make us leave. It's winter. I want you to leave now. No,
Right.
when this happens,
Right.
that thing.
I got it. Thank you.
No problem.
Any other questions for Investigator O'Reilly? Seeing none, we've heard from the parties and the investigator. At this time, we'd be looking for a motion. There are 2 proposed findings.
Well, I'll move that we take them together and that we find there's no reasonable grounds to believe that respondents discriminated on the basis of sex, orientation, or for engaging in Maine human rights protected activity, and that the complaint should be dismissed.
Second,
Second.
it's been moved and seconded. Is there any discussion? Being none. Go ahead.
No.
I mean, these facts are deeply troubling. And the reality, for me anyway, is that the temporality is really compelling for me, insofar as it serves to meet the standard for a finding of reasonable grounds here. I understand that each party, they have credibility issues, right, associated with how they participated in the investigation with investigator O'Reilly. And so those are the factors for me that cause me to want to vote for a finding of reasonable grounds.
Leave me alone.
Douglas and then
Okay, since I was folks here, I agree with everything that you said, except I just find the fact that the rent wasn't paid for months beforehand. I agree this is a very troubling case, and I agree that the things that are alleged here are, it's deeply troubling. But I also, the fact that they didn't pay rent March, April, May, June, July, August. I guess there was one verbal agreement that they sort of blew through and they didn't pay. It's a tough case, but I think I'm going to fall on the no reasonable ground side. In accordance with the motion.
I too agree with almost everything you said, and in those cases where it is troubling, it's just, credibility is a major concern or issue here. Who has the most credibility, and in those cases, they yield to the investigator. So the arguments and analysis by the investigator is what led me to it.
Yeah, I think Attorney Neal's argument was persuasive to me, right? That the non-payment of rent wasn't an issue till it was an issue, right? And what's the causal connection? Well, we can infer that not 24 hours before, right? Or very close in that time frame. We had this pretty ugly incident with their child, and then all of a sudden, right? Okay, now we're going to move through with the eviction process. We're not going to be able to come to some kind of an understanding. So that's the part for me that's troubling. It's the timing.
Any further discussion? Seeing none, the motion is to find no reasonable grounds. If you're in agreement, you will vote yes. Commissioner David.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
No.
All right, the motion is no reasonable grounds. The findings are no reasonable grounds. We appreciate everyone's participation. The commission will send a letter to the parties and council confirming the results of the hearing. And that concludes our hearing agenda for the day. Well done, everyone. Make yourselves whole before the sun goes away.
Be safe too.
Yeah.
Thank you all. See you in May.
All right, thanks.
Take care.